Much for that. So many reactions, and now I am joined by Dr. Dion George, who is the DA Shadow Minister. Thank you so much for joining us today. The Minister has spoken. What are your thoughts?
Well, as expected, it was a bailout budget for the ANC. The Minister is now going to take 150 billion rand out of the contingency reserve of the Reserve Bank and basically throw it into a massive pit of debt, basically, and it's not going to make any difference whatsoever. What the Minister needed to do was to make structural reforms. So, for example, cut back on the public sector wage bill and also not continue to bail out the state-owned enterprises. Although there is no direct bailouts, we still have the transfer of the debt onto the national balance sheet, which means that this is not going to sort out any problem with the debt at all. But most importantly, he completely ignored vulnerable South Africans. There are 5 million starving children in South Africa, according to the Nelson Mandela Children's Fund. He did not increase the child grant, which he could have done, although the social relief of distress grant will remain for another year. What happens after that, we don't know. And also what he could have done is he could have cut back on tax. For example, he could have cut the fuel tax, which would have made transportation less expensive and reduced the price of food. He could have expanded the zero VAT-rated food basket, but he did not do that. And
The House Chairperson.
Please be seated. Order, honorable members. Honorable members, take up your allocated seats. Thank you. Honourable members, I would like to draw your attention to the books of condolence for the late Honourable Alice Lebani Mtembu and the Honourable Violet Sizani Siwela, which have been placed between the back entrance of the hall and the David Bloomberg room. Members are invited to sign the books of condolence at the end of today's sitting. The books will be presented to the families during the condolence motions that is scheduled for the 5th of March 2024. Thank you. The Secretary will read the fourth order.
Consideration of recommendations for removal from office of Judge President M.J. Hlophe in terms of Section 177, subsection 1 of the Constitution of the Republic of South Africa, 1996.
I now invite the Honourable Magwanishe, who will introduce this debate.
Thank you very much, House Chairperson. His Excellency the Deputy President, the Speaker of the National Assembly, the Deputy Speaker, Ministers and Deputy Ministers, honorable members. There is a Latin phrase which states, quis custodiat ipsos custodes. Loosely translated, it means who will guard the guards themselves, or who will watch over the watchmen, or who will judge the judges. At the heart of this phrase lies the question, how will those who wield power and are entrusted to protect us be held accountable? After centuries of oppression, discrimination, dispossession, and grave injustices, the democratic breakthrough ushered a paradigm shift. The adoption of the Constitution ushered in a new order in form and in substance, from the supremacy of Parliament to a constitutional democracy, in which the Constitution is the supreme law, and any law and conduct inconsistent with the Constitution is invalid. We adopted the Constitution and constitutional democracy as our new path. Our Constitution is reflective of the kind of a nation we chose. We chose to have a country built on the supremacy of the Constitution, espousing human rights culture and respect for the rule of law, applicable to all persons in equal measure. Our constitutional structure embodies protection from abuse of power. The texture of our Constitution is measured by systems of accountability with appropriate checks and balances. We can confidently say that it is the Constitution which chose the judiciary as the guardian of our nation, our people, our institutions, our democracy, and the Constitution itself. Courts are the final arbiters in disputes. The judiciary is often referred to as the last line of defense. A great deal of responsibility rests on the shoulders of the judiciary, so much that the Constitution guarantees its independence. If a court does not have independence, it cannot function as a court. Judicial independence stems from the doctrine of separation of powers and is at the heart of the rule of law. Our judicial system requires of every judicial officer sitting alone or in a panel to apply their mind independently and without succumbing to the influence of fellow judicial officers. It entails that a judge must take all reasonable steps to ensure that no person or organ of state interferes with the function of courts. A judge bears the responsibility of upholding the independence, integrity, and authority of the courts. When the very same judges are found wanting, how do we then hold them accountable? Who judges the judges? Judicial Services Commission is an important organ of state. It safeguards judicial competence and independence. Its composition includes members of the judiciary, legal experts, executive, and the legislature. The JSC functions to protect the judiciary from undue influence, preserve judicial independence, and regulate judicial ethical conduct. In regard to judicial ethical conduct, the JSC is the jury of the nation. On the 30th of May 2008, 11 justices of the Constitutional Court lodged a complaint with the Judicial Services Commission against Judge President of the Western Cape Division of the High Court, Judge John Hlophe, alleging that during discussions with Justices B. Nkabinde and C. N. Jafta, both of the Constitutional Court, he improperly attempted to influence the Constitutional Court's pending judgment in Zuma-tint matters. After several years of delay occasioned by various litigation, a judicial conduct tribunal appointed by the Chief Justice to investigate and report on the complaint found Judge Hlophe's conduct to be in breach with the provision of Section 165 of the Constitution, in that he improperly attempted to influence the two justices of the Constitutional Court to violate their oath of office. Additionally, the JCT found that Hlophe JP's conduct threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court, and in that it threatened public confidence in the judicial system. The JSC, having considered the JCT's report, the record and submissions from the parties by majority decision, decided to uphold the JCT's decision that Judge Hlophe is guilty of gross misconduct as envisaged in Section 177 of the Constitution. Section 177 of the Constitution provides for the removal of judges, setting out a three-stage process as follows. A judge may be removed from office only if the Judicial Services Commission finds that the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct, and a National Assembly calls for that judge to be removed by a resolution adopted with a supporting vote of at least 2/3 of its members. The President must remove a judge from office upon adoption of a resolution calling for that judge to be removed. In the matter of Hlophe versus the Judicial Services Commission, at paragraph 152 to paragraph 155, the South Gauteng High Court clarified the distinctive roles set in Section 177 of the Constitution and proper parameters for those roles, and held that, and I quote, the structure of Section 177, subsection 1A, plainly provides that a judge can be removed if the JSC finds that the judge is guilty of gross misconduct. That finding is a jurisdictional precondition to the National Assembly contemplating a resolution to remove a judge. The decision as to whether misconduct occurred is that of the JSC alone. There is no provision in Section 177 for rehearing of the complaint by the National Assembly. Guided by the High Court's interpretation of Section 177 of the Constitution, the committee developed steps to allow for sufficient engagement with the affected judge and deliberations to empower its members to make an informed political decision about the remedy determination as a consequence of the JSC finding. The matter was referred to the Committee for Consideration and Report on the 2nd of September 2021. Shortly after the matter was referred to the committee, Hlophe JP took JSC decision of the 25th of August 2021, in which its majorities resolved that he had committed gross misconduct on review. On the 5th of May 2022, a full bench of the Johannesburg Division of the High Court in the Hlophe judgment dismissed the application, stating that Hlophe JP had failed to raise grounds for proper review. On the 14th of September 2023, the National Assembly Programming Committee at its meeting resolved that the committee should proceed to consider the JSC findings of gross misconduct for recommendation to the National Assembly as to whether a removal should follow as a consequence. Regarding the procedure to be followed, the committee noted the clarity provided by the Hlophe judgment on the specific roles assigned to the JSC and the National Assembly in giving effect to Section 177 of the Constitution. The committee developed steps to allow for sufficient engagement with the affected judge and deliberations to empower its members to make an informed political decision about the remedy determination as a consequence of the JSC finding. The court clarified that the National Assembly's role is not to rehear the matter, as that question is a question of merit already settled at the JSC finding stage. In making its determination, the National Assembly makes a political decision. The committee wrote to Judge Hlophe in a letter dated 4th October 2023, inviting him to place any extenuating circumstances that he considered relevant to the committee's deliberation as to whether his removal from office is an appropriate response to an already proven gross misconduct. The representation should be in writing and should reach the committee by no later than 15th November 2023. In response, the committee received a letter from Hlophe JP dated 17 October 2023. The committee considered the contents of the letter at the meeting of the 24th of October 2023 and replied to him on the 25th of October 2023, inviting him once again to make representations on any extenuating circumstances that he considered relevant as to whether his removal from office is the appropriate response to the already proven facts. The committee requested that he refrain from addressing merit issues already settled in terms of the JSC process. The committee noted as a legal fact that the JSC's findings of gross misconduct against Hlophe JP referred to the National Assembly in terms of Section 20, subsection 4 of the JSC Act, read with Section 177, subsection 1 of the Constitution. The National Assembly, as an extension of Parliament, exercises public power. In the case of the state versus Mokwanyane, the Constitutional Court said that the exercise of public power, including lawmaking, should be rational and not arbitrary. Rationality is understood as a rational relationship between the measures adopted and the legitimate government purpose. As we take this decision on this matter, it is important that we remind ourselves that our decision must be rational. The process of removal of a judge in a democratic South Africa is not an occasion for adulation and celebration. This process is one of accountability and gives us an opportunity to reflect as a nation. Fellow South Africans, this process of accountability has emphasized the point that to whom much is given, much is required. The Portfolio Committee on Justice and Correctional Services, having considered the letter from the Acting Deputy Chief Justice of the Republic of South Africa and Acting Chairperson of the Judicial Services Commission, Justice S.S.V. Khampempe, on the Judicial Services Commission's decision relating to a complaint brought by justices of the Constitutional Court against Judge President M.J. Hlophe, the majority and the minority decisions of the Commission, as well as the report of the Judicial Conduct Tribunal submitted in terms of Section 177 of the Constitution, referred to it, recommends that the National Assembly resolve to call for the removal of Judge Mandlakaise John Hlophe from office.
Thank you, Honourable Member. The next speaker is the Honourable Breitenbach.
House Chair, honourable members, the impeachment of Judge President John Hlophe stands as a pivotal moment in the annals of the South African judiciary. It requires us to delve into the intricate layers surrounding the impeachment proceedings, examining the allegations and the legal framework, and the broader implications for judicial integrity and accountability. John Hlophe, a prominent figure within the South African legal sphere, served as Judge President of the Western Cape Division of the High Court. His career was not devoid of controversy, both personal and professional, but it was the allegations of egregious misconduct that sparked this impeachment process. Hlophe had it all going for him. exceptionally well educated, clearly extremely intelligent. He had all the makings of a stellar judicial career. When appointed by President Mandela, he was the youngest judge to be appointed to the bench. Yet he was tripped up by the lack of that most essential component of any judge, integrity. Hlophe has demonstrated amply that he possesses no shred of integrity. And for that reason, he will become the first judge to be impeached since the dawn of democracy. The allegations against Hlophe revolve around seriously improper conduct related to several high-profile cases. He has been found to have improperly attempted to influence Constitutional Court justices in matters involving the corruption charges against then-President Jacob Zuma. This interference raised serious concerns about the impartiality and independence of the judiciary as a whole. This process, initiated by the DA in 2008 against Judge President Hlophe, was protracted and complex. It involved extensive investigations, hearings, and deliberations by the Judicial Service Commission. Political interference, legal technicalities, and public scrutiny complicated the proceedings. Civil society was forced to join the fray, there being a perceived distinct lack of appetite to deal with Hlophe and his nefarious activities. It is a great indication of our Constitution and the rule of law that we have finally reached this point, albeit very belatedly. The impeachment of Hlophe, or any judge, has profound implications for judicial integrity in South Africa. It underscores the importance of upholding the highest ethical standards amongst judicial officers. It also sends a clear message that no one, regardless of their position or influence, is above the law. Moreover, it reaffirms the principle of judicial independence as the cornerstone of democracy and boldly underlines the principle of the rule of law. This debate highlights the need for robust mechanisms to address allegations of judicial misconduct promptly and effectively. It also emphasizes the importance of transparency and accountability in the judiciary. Furthermore, it underscores the role of public trust and confidence in the legitimacy of judicial institutions. The impeachment of Hlophe represents a critical moment in our legal history. It symbolizes the country's commitment to upholding the rule of law and preserving the integrity of its judiciary. Moving forward, it is imperative to learn from this experience and strengthen the mechanisms for safeguarding judicial integrity in South Africa. Hlophe tried a final roll of the litigious dice by attempting to interdict the impeachment vote in Parliament today. He was always fighting a losing battle. But in doing so, he has underscored the fact that he cares nothing at all for the judiciary, its image, nor its integrity. He has again placed his own narrow personal interests above those of the South African people. He has demonstrated again that he is wholly unsuitable to be a judge. The doctrine of the separation of powers is an integral part of South Africa's constitutional setup. It means that we, the members of the National Assembly, cannot second-guess the JSC's legally binding decision that Hlophe stands to be impeached. It is the function of the JSC to decide on gross misconduct on Hlophe's part, and it has done so. The role of the National Assembly is confined to voting on whether to call upon the President to remove Hlophe from office. This conclusion is the only legally viable interpretation of the wording of Section 177 of the Constitution. Hlophe is hoisted by his own petard. He deserves no sympathy in the vote now before this House. He has done great damage to the administration of justice, especially in his own division, and his antics have undermined the rule of law. He has tainted the image of the entire bench, and it will take a long time to eradicate the odour of his antics. All parliamentarians who have read the Zondo Commission's report should today know where their solemn duty to uphold the rule of law lies. We urge all members to support the recommendations of the committee. I thank you.
The next speaker is the Honourable Kwebane.
Chairperson, today this House is required to endorse what is essentially a culmination of a concoction of deep-rooted racism in the judiciary, the political vindictiveness of the ruling elite, and the failure of the post-1994 establishment to create conditions for black men and women to prosper in legal profession. Judge President Hlophe, a distinguished judge and an exceptional legal scholar, is about to be the first victim of a toxic and unforgiving culture of impaling black people who dare stand up against the dominant liberal and racist discourse in this country, and which is more pronounced in the Western Cape. His only sin is that he simply discussed law with his colleagues. Let's give a brief timeline of why we are here. 30 May 2008, 11 justices of the Constitutional Court lodged a complaint with the JSC against Hlophe, alleging that during the discussion with Justices Ctnd and Jafta, both of the Constitutional Court improperly attempted to influence the Constitutional Court. 30 June 2008, Judge Hlophe expressed concerns about political motives and inappropriate pressure when Justice Ctnd and Jafta declined to bring a complaint against him. July 2008, Hlophe filed a High Court application alleging unconstitutional conduct by the justices of the Constitutional Court. The application claimed infringement of his rights to human dignity, privacy, fair hearing, equality, and access to courts. September 2008, court ruled that some of Hlophe's rights were limited and were limitedly violated. However, in 2009 March, the Supreme Court of Appeal reversed the High Court's finding of infringement of his rights. Subsequently, in August 2009, the subcommittee of JSC found no sufficient evidence for gross misconduct against Hlophe. Despite this, August 2009, the Judicial Service Commission issued a rebuke and a caution. So that's the first time he was not found guilty of any gross misconduct. Coming back to the very same issue, that then there was this Judicial Conduct Tribunal, which was established after that incident, which proceeded to reinvestigate the matter and proceeded, which Judge Ctnd and Jafta lodged a court application indicating that they were reviewing this decision because that was not properly done, but then they also lost in a court. Then finally this matter was heard before the tribunal, and the fact of the matter is that Judge Hlophe raised this matter and even brought during the hearing an expert witness who testified ngesizulu asho ukuthi lokakushilo kwakukuthi bayasebenzisana namanye amajaji. And indeed the corrections were made to the statements during that particular hearing. Consequently, Judge Hlophe also contended that the JCT and JSC exceeded their powers in the exercise of their powers, and they acted beyond their powers. So he further holds that the National Assembly should have engaged the JSC's finding beyond simply just accepting it. Because we remember that even the Premier of the Western Cape, Judge Wind, also was one of the culprits. There was a lot of political interference and even the jealousy and the treatment which Hlophe received from his counterparts. We reject this selling out of our liberation ideas. We reject the abuse of Judge Hlophe and deem all of this unconstitutional behavior. The judge was tried twice. When the first hearing exonerated him, but we have bugging people who have racist tendencies, and the freedom under law, also under Mr. Kriegler, who has been found guilty as well of acting out of his mandate. So they abuse Judge Hlophe. This is not about justice. It is about gross misconduct of Judge Hlophe. In the main, about whites flexing their power over their puppets in government to punish Hlophe, Tumbeza, Bantu BaKwaZulu-Natal, Ndeni wakaHlophe, wakwaTumbeza. We know as EFF that the judge was highly qualified and he did his work with dignity. Punish this ANC government. Thank you.
Thank you, Honourable Member. The next speaker is the Honourable Singh.
Thank you very much, Honourable Chairperson. I've learned over many years as a father, grandfather, politician, and a person serving on a number of committees that facts must speak for themselves, irrespective of race, color, creed, or religion when considering any matter. And in this case, after having read the reports and gone through the facts, there is no doubt that the conjecture that we just heard from the previous speaker cannot trump the facts. The judiciary, Honourable Chairperson, plays a vital role in upholding and adjudicating the law and ensuring justice. Therefore, it is crucial that judges exemplify good conduct, both professionally and privately. Any failure to do so can erode public trust and confidence in the rule of law, which is essential for maintaining the integrity of the legal system. Judges are the final arbiters of justice, and any indication of impropriety can undermine the credibility of their decisions and negatively impact public trust. Therefore, judges must demonstrate integrity and adhere to ethical standards to uphold this rule of law. When judges exhibit integrity, they are viewed as honest, ethical, and reliable, which enhances public confidence in the fairness and impartiality of the legal process. Currently, Honourable Chairperson, this House will be considering two matters that involve the removal from office of two judges. This is being done, as we've heard, under Section 1771B of the Constitution, and is based on allegations of gross misconduct. One of the concerns that we have is the IFP is the delays that it takes, the long delays that it takes before this matter is finally considered. In the matter of Judge Hlophe, the first complaint was lodged in 2008, and it's 16 years later that we are considering this matter. However, we all know that the law must take its course, and there are provisions for appeal mechanisms, which the Honourable Judge has used. Honourable Chairperson, I serve, and I've been serving on the Judicial Services Commission now for 15 years. This is my 15th year. And sometimes people misconstrue the JSC, which is the one that some of us politicians serve on behalf of Parliament, and what is called the small JSC, which excludes us members of Parliament when matters of judicial conduct, allegations of misconduct are considered. It was the small JSC that considered this matter, because we cannot be referees and players at the same time. And then this matter, as we heard, also went to the Judicial Conduct Tribunal, where the JCT found that Judge Hlophe's conduct threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court. Furthermore, they found that it threatened public confidence in the judicial system. We want to agree that Judge Hlophe is a renowned judge. He's really a jurist of note that has been a person where many, many young black jurists have followed his career path. It is unfortunate that we have to come to the stage where it will be the first time in the history of this Parliament and at the end of the 6th Parliament that a judge has to be removed from office. We had another impeachment not so long ago, but that was another matter. So, Honourable Chairperson, the IFP will support the recommendations contained in this report. Thank you very much.
Thank you, Honourable Member. The next speaker is the Honourable F.J. Mulder.
Thank you, Honourable House Chair. If Judge President Hlophe is removed today, history will be made for all the wrong reasons, but it will show in the end that South Africa's constitution, while tested to the limits by the likes of former President Zuma and Judge President Hlophe, has held fast, but not without being scarred and bruised. This is a moment of truth not only for South Africa's commitment to the rule of law, but also in understanding the political theatre that has plagued the country's judiciary for almost 2 decades. House Chair, in April 2021, 17 years after Oasis and 13 years after Hlophe's attempt in 2008 to influence constitutional judges seized with President Zuma's corruption probe matter, the Judicial Service Council Tribunal added a footnote for the history books of South Africa. Judge President Hlophe, while consistently paying lip service to and apparently embracing the values of the Bill of Rights and the Constitution, has from the word get-go publicly behaved in a manner contrary to his declarations of fidelity to the rule of law or even common human decency. His actions have undermined every purpose of the Judicial Service Council, which is to prevent perceived and real political influence in the judiciary. Chair, in his appeal against the JSC Tribunal finding of gross misconduct, Judge President Hlophe sought to paralyze the entire system of accountability, suggesting every single judge on the country was compromised and had no right to sit in judgment. The Judge President litigation mission was aimed at avoiding the far-reaching and devastating consequences to him personally should he be impeached. Agbare Voorsitter, President Ramaphosa het uiteindelik hier aan die einde van die 6de termyn of die 6de parlement 'n stap geneem waarmee die VF+ kan saamstem. Die VF+ steun die aanbeveling om regter-president Hlophe uit sy ampt te verwyder. Dankie.
Thank you, Honourable Member. The next speaker is the Honourable Swart.
Thank you, Chairperson. Chairperson, the ACDP wishes to agree with the Chairperson of the Justice Portfolio Committee, the Honourable Magwanisha, to whom much is given, much is required. And the SCA has already found that a judge is the pillar of our entire justice system and of the rights and freedoms which that system is designed to provide and protect. And so we need to be very sober-minded as we consider the implications of today's impeachment. We're not only impeaching for the first time a judge, but a judge president of the High Court. But that having been said, no one is above the law, not a judge, nor a judge president. And we clearly need to strengthen the mechanisms. It can't be correct that it takes so long for a matter like this to be finalized, with a lot of litigation involved. And yes, everyone is entitled to approach the courts for reviews, but it has taken a number of years to reach the conclusion that the Judicial Services Commission found on the merits, having considered the Judicial Conduct Tribunal and the decision that Judge President Hlophe is guilty of gross misconduct as envisaged in Section 177 of the Constitution. Now, it's very important to bear in mind that we are dealing today, as the Supreme Court of set out, and the Constitutional Court, that there are different roles assigned to the Judicial Services Commission and the National Assembly. They are not overlapping. Neither the National Assembly nor the Judicial Services Commission are subordinate to one another. The Judicial Service Commission is vested with the power to make a decision based on the norms of judicial ethics, in other words, the merits of the case. The National Assembly looks into the matter and takes a political decision. We are not here to reconsider the merits of the matter. This is a political decision. Our role is confined to voting on whether to call upon the President to remove the Judge President from office. The committee fully considered the documentation before it, including written submissions from Judge President Hlophe, applied its mind through deliberations, and by majority noted the arguments placed before it and found no extenuating circumstances that would support a decision on its part not to recommend that the National Assembly be resolved to call for the removal of Judge President Hlophe from office. The ACDP supports this report and the impeachment of Judge President Hlophe. It is anything but a concoction of deep racism in the legal profession. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Kwankwa.
House Chair, Thank you very much. The step we are undertaking today confirms once more that no one is above the law, and that those who have been found wanting, those who have not been up to the exacting standards expected of a judge, be dealt with, and those in our different arms of government who do not live up to the expectations of their office, be held to account. Asizuthi kuba abantu bemosha athi kube mnyama funeka singamohlwayi. Okusalayo sizawuyenza loo nto. Abe nithethile abantu izuva ngani? Banozixhoma. Judicial misconduct breaks down the very fiber of what is necessary for a functional judiciary. And perhaps like Caesar's wife, those who run such office should be above and beyond reproach. And unfortunately, in this instance and in this case, Judge Hlophe was found wanting, and for that he must be held to account. And we are here as a party to say we support the recommendation for Judge Hlophe to be impeached, and that his matter was simply put. There's a difference between will and judgment. What he attempted to do, the allegations contained in that report, show that what he preferred was, what he was actually doing was trying to impose his will, as opposed to allowing colleagues to interpret and apply the law and evaluate whatever matters that were before them for their consistency or lack thereof with the Constitution. Isn't that what is expected of anyone who holds an office as a judicial officer? Right? So, an imposition of will or policy preference on the part of those who hold that office is a betrayal, constitutes a betrayal of your judicial duty, isn't it? And if you have done so, what must we do? Come here, play politics, use political rhetoric, and be afraid of taking the necessary decisions that we must take in order to uphold, maintain, and keep the independence of the judiciary. Asizukujika, asizuphosisa, injalo, we support the recommendation. Asizumosha apha kuba simnyama senze into ezingekhoyo, and we run divisions as if they are our fiefdoms, and then we expect not to be held to account when we are found wanting. Thank you.
Thank you, Honourable Member. The next speaker is the Honourable Machal.
Thank you very much, House Chair. The African Transformation Movement stands firmly behind Judge President John Hlophe amidst the calls for his impeachment. Judge Hlophe's contribution to the judiciary and his steadfast advocacy for decolonization of the legal framework cannot be overlooked. Throughout his tenure, he has tirelessly worked towards ensuring that African indigenous law is given the recognition and respect it deserves within our legal system. Throughout his tenure as the Judge President of the Western Cape Division of the High Court, Judge Hlophe has left an indelible mark through his dedication to justice and his tireless efforts to advance the cause of decolonization within the legal system. In 2004, Judge Hlophe courageously addressed issues of racism within the legal profession by submitting a comprehensive report to Chief Justice Pius Langa. This report highlighted instances of racial discrimination within the Western Cape High Court, demonstrating his commitment to upholding fairness and equality in the legal system. Judge Hlophe has been a vocal advocate for the recognition and evolution of African indigenous law within the South African legal framework. His efforts to ensure that African legal traditions are given due respect and consideration have been instrumental in promoting cultural diversity and inclusivity within the judiciary. Judge Hlophe's jurisprudence has contributed to the development of landmark legal decisions and precedents that have shaped the legal landscape in South Africa. His judgments reflect a deep understanding of the complexities of the law and a commitment to uphold justice for all citizens, regardless of background or status. It is imperative to acknowledge that the current legal framework in South Africa is deeply rooted in Roman Dutch law, which often marginalizes African indigenous law. Judge Hlophe's efforts to challenge the status quo and elevate African indigenous law are commendable and align with our vision for a more just and equitable legal system. It is crucial for this House to recognize his unwavering commitment to advancing the cause of justice for all South Africans. We firmly believe that Judge Hlophe's leadership is integral to the ongoing transformation of our legal system, and we stand by him in his endeavors to decolonize and uplift African indigenous law. It is deeply troubling to witness the concerted effort by the ANC government, often with the support of the sister parties, the Democratic Alliance, to undermine the credibility and integrity of black professionals within the legal system and often in other professions. Judge President John Hlophe's unwavering commitment to challenges the status quo and advocating for meaningful transformation has undoubtedly ruffled feathers among those who benefit
Honourable Member,
from the
your
papers.
time is now expired.
We stand behind Judge
Thank
Hlophe
you.
and affirm our full support and pantsing impeachment ka Judge Hlophe phansi.
The next speaker is the Honourable Herron.
Thank you, House Chair. House Chair, today we face the unenviable task of implementing Section 177 of the Constitution to consider the removal of Judges Hlophe and Motata. South Africa's judicial system is a key instrument for the maintenance of its overarching integrity. All people and sectors of society depend on the judiciary's impartiality and independence in order to be able to hold the state accountable for its integrity and the integrity of its administrative decisions. In this space, judges cannot be viewed as harboring political agendas. Ultimately, an impartial and independent judiciary provides the bedrock of confidence in our democratic order. The system relies on the fact that no one can be above the law, not a judge president, and not even a president. That's the constitutional, besides ethical, principle that we are tasked with demonstrating today. Chapter 8 and Section 165 of the Constitution provides that the courts are independent and subject only to the Constitution and the law, and that no person may interfere with the functioning of the courts. And Section 174 of the Constitution requires that our judges are fit and proper persons. The Judicial Services Commission has discharged its constitutional duty to conduct hearings to determine whether these judges are guilty of gross misconduct. Ours is not to debate the merits of those findings. We were not party to the evidence or to second-guessing the JSC's ruling or finding. The courts have said the decision as to where the misconduct occurred is that of the JSC alone. The National Assembly receives that finding as a fact and deliberates thereupon not to reconsider it, but to decide what to do based on it. Where those who are trusted with ensuring the rule of law is enduring and seen to be done and found to have broken the law and have been found guilty of gross misconduct, then there's a duty on the National Assembly to reinforce the principle of the Constitution and the rule of law. That requires us to support the committee's recommendations in both cases and remove the judges from office. Thank you.
Thank you, Honourable Member. The next speaker is the Honourable Ramalobeng.
Thank you, House Chair, Deputy President of the Republic, members of the Executive, Chief Whip, and all members of the legislatures and honourable members. As we debate on the removal from office, a member of the judiciary embarking on a novel process in the democratic dispensation, it is befitting to remind ourselves of what our former Chief Justice Arthur Chaxlin had to say, open quote, "Judicial independence is a requirement demanded by the Constitution, not in the personal interest of the judiciary, but in the public interest. For without that protection, judges may not be or be seen by the public to be able to perform their duties without fear or favor," close quote. Judicial independence entails the ability of a judge to make a decision without undue influence and interference from internal and external forces. Moreover, the judge must have security of tenure and financial security in order to guard against bribery and related interference and corrupt conduct. Furthermore, the judiciary must manage its own administrative functions and activities. In essence, a judiciary that does not have individual or personal and institutional or functional independency falls short of the core requirements of judicial independence. House Chair, the core function of a judge is to form a view from the facts and the law and to make a determination or take a decision. Our judicial system requires of every judicial officer sitting alone or in a panel to apply their mind independently and without succumbing to the influence or pressure from a fellow judicial officer, Honorable Mkhwebane. Ethics instructs a judge to avoid apparent or real conflict of interest, and impartiality is a central pillar of any judicial role. House Chair, in the case of Ngabinde versus the JSC, the Supreme Court of Appeal referenced a Canadian Supreme Court judgment that related to a Canadian judge, but that was equally applicable to South Africa. The salient points of the Canadian judgment were as follows. Firstly, the judicial function is absolutely unique. Apart from their traditional role as arbiters of disputes, judges are also responsible for preserving the balance of constitutional powers and have to become one of the foremost defenders of individual freedoms and human rights and guardians of the values the Canadian Charter embodies. Secondly, the judge is a pillar of the entire justice system and of the rights and freedoms of which the system is designed to promote and protect. Lastly, Chair, accordingly, the personal qualities, conduct, image that a judge projects affect those of the judicial system as a whole and have a significant impact on public confidence in an effective judicial system and in a democracy founded on the rule of law. Chairperson, the Judicial Service Commission, which has been described as a jury of the nation when disciplining judges, did not, on the facts, accept that Judge President Hlophe had no intention to influence the two judges. It also did not accept that Judge President Hlophe was ignorant of an obvious norm of ethical behavior amongst judges restricting their discussions about pending judgment. A free and independent judiciary is crucial to the success of a relatively young democracy. The independence of the judiciary must always be protected. In a constitutional democracy, the judge's responsibilities goes beyond a high standard of judicial and legal professional conduct. They are expected to be individuals with the integrity not only to speak the values contained in the Constitution, but also to act in a way that demonstrates integrity with respect to the supremacy of the Constitution and the rule of law. House Chair, the Portfolio Committee received Judge President Hlophe's submission on extenuating factors that it was dealing with the matter and the committee was not persuaded. We are confident that we have applied our minds to the facts and laws before us and are of the view that the shortcomings of the Judge President Hlophe are so serious to destroy confidence in the judge's ability to properly perform the judicial function. House Chair, the African National Congress supports the report that has been tabled here. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Jafta.
Thank you, Honourable Chair. In his formal complaint to the Judicial Service Commission against Judge President Hlophe, the then Chief Justice Pius Langa said the following, I quote, "The attempt to influence Ngabinde J and Jafta CN was calculated to have an impact not only on the individual decisions of the judges concerned, but on the capacity of the Constitutional Court as a whole to adjudicate in a manner that ensures its independence impartiality, dignity, accessibility, and effectiveness as required by Section 165, subsection 5 of the Constitution, close quote. President Hlophe has no regard for the rule of law. He does not respect the Constitution, the people of South Africa, and this Parliament. Just recently, he was mounting a relentless fight against the Speaker of this Parliament, demanding that Parliament halt its impeachment proceedings against him pending his application to the Constitutional Court. As a judge, President Hlophe must appreciate that Parliament has not been interdicted to proceed with this matter. It is ironic that it was Judge Hlophe in Patricia de Lille versus the Speaker of the National Assembly who cautioned that Parliament, however, its eminent scholarship cannot engage in conduct that is not sanctioned by the Constitution. By trying to prevent Parliament from carrying out its mandate as sanctioned by the Constitution, Judge Hlophe is not living up to his judgment. The behavior of Judge Hlophe and his conduct is at variance with the oath of office he took before ascending to the bench. This impeachment must send a clear message to judges that the only bias they are required to have is to the Constitution. Judges must also remain biased towards the rule of law, the people of South Africa, and their oath of office. Judge Hlophe is disgraceful. His conduct is criminal. It is akin to committing treason. In removing Judge Hlophe from the bench, we will be honoring the legacy of the likes of Justice Shackleton, Justice Langa, Justice Square, and Advocate George Bizos, who tirelessly sought to protect the image of the courts and promote judicial independence. The AIC supports the recommendation of the committee. Thank you.
Thank you, Honourable Member. The next speaker is the Honourable Lakota. Order, Honourable Members.
Honourable President, members of the House, we have looked carefully through the documentation that's come with the recommendation. We are quite satisfied that the men and women, we, the Congress of the People, we are satisfied. I ask for your protection.
Order, Honourable Members. Order.
Protection.
Order,
Chairman.
Honourable Members.
We are satisfied that the men and women who were tasked with the task of evaluating the case and made the recommendation they made to the House were competent, and we support the recommendation.
Order, Honourable Members. The next speaker is the Honourable Nyonso.
House Chairperson, the PAC of Azania once more will reject this report by ANC of South Africa. The point is that Parliament is independent. It is a third arm of government. It cannot just take a report from the judiciary and vote on it. This is against the separation of powers. Parliament should set an ad hoc committee to look into this. This is more so because it is the judges themselves who are fighting. They cannot therefore impose their differences on Parliament. Parliament does not have rules on how to remove a judge. They must be done first. On the merits, judges discuss legal matters with other judges. This happens every day. He is accused of trying to influence two judges, but they say they didn't feel influenced and he did not push his views. So said they are not complaining about anything. The senior judges then complained as a court. Judge President is innocent. He must be allowed to resume his duties. Ndiyaqala ubona abantu abalwela inkululeko bathi bawukhululeka balwe naba bantu bebalwela.
Thank you, Honourable Member. The next speaker is the Honourable Hendricks.
Honourable House Chair, in the late 1989, the Regional Court President made recommendations regarding imposition of sentencing in South Africa. Consequent to Parliament's acceptance of the Kruger Committee report, Parliament enacted the provisions of Section 276A of Act 51 of 1997. This marked a shift from punishment to rehabilitation within the South African criminal justice system. This shift was further entrenched by the recognition and implementation of the concept of restorative justice. It is submitted that the suitable punishment to be imposed upon the Honourable Judge Hlophe will be a fine of 10,000 rand, wholly suspended, and not impeachment. Impeachment must be a matter of last resort, and alternative to Parliament is the prerogative of Parliament. Honourable members have a historic opportunity to show that the Sixth Parliament is a people's parliament, embracing African values, and African sanctions are not Western prescripts, which in this case will be counter-revolutionary. We'd like to thank Judge Hlophe for his services to the country. Al-Jamaa feels that each remedy is revolutionary, fair, and will contribute to nation building. In addition, the common law principle of sub judice has become completely emasculated by the entrenched provisions of Section 16 of Chapter 2 of the Bill of Rights of the South African Constitution. There are reports daily on South African television, newspapers, and radio where comments and opinions are expressed about pending cases. The only difference is that the Honourable Judge Hlophe conveyed the sentiments concerning a pending case against the former President Zuma personally to two judges. He should not have done so. Honourable Chair, Al-Jamaa calls on honourable members of Parliament and President Ramaphosa not to implement the impeachment of Judge Hlophe. His tenure showed that that black judges can dispense justice, and it is not the domain of whites only. The IFP confirmed that Judge Hlophe is a renowned judge. The Honourable Judge Hlophe served the judiciary for more than a decade. Since the wrong for which he has been found guilty in 2008, Judge Hlophe should be shown compassion. He is elderly, and to harm his livelihood and well-deserved retirement benefits is out of place in our country with values like Ubuntu. Thank you very much.
Thank you, Honourable Member. The next speaker is the Honourable Horn.
House Chair, Constitutional Principle 6 of the Constitutional Principles agreed upon in the early 1990s and annexed to the interim Constitution provided that there shall be a separation of powers between the legislature, executive, and the judiciary with appropriate checks and balances to ensure accountability, responsiveness, and openness. When certifying the 1996 Constitution, the Constitutional Court remarked as follows: there is, however, no universal model of separation of powers in democratic systems of government, in which checks and balances result in the imposition of restraints by one branch of government upon another. There is no separation that is absolute. The principle of separation of powers, on the one hand, recognizes the functional independence of branches of government, but on the other hand, the principle of checks and balances focuses on the desirability of ensuring that the constitutional order as a totality prevents the branches of government from usurping powers from one another. Now, House Chair, the duty and authority of this National Assembly in terms of Section 177 of the Constitution to deal with the item under discussion is exactly part of the checks and balances system in our constitutional arrangement. The President, as head of the executive, will be duty-bound to remove a judge from office if the JSC has found gross misconduct on the part of the judge, and if the National Assembly, with 2/3 of its members supporting such a resolution, calls on the President to do so. The Constitution is very clear in this regard, House Chair, and it does not require, as has been confirmed by our courts, a fresh investigation on the part of the National Assembly. So what we must therefore understand is that whilst most of our responsibilities as the National Assembly are to be performed ordinarily within the context of policy and politics, the constitutional obligation to consider the possible removal of judges is different. The Constitution writers left ample opportunity for political considerations to determine the outcome of our work when we make laws and when we oversee the work of the executive. But, and this is in our view instructive to us as an assembly today, we are not performing legislative or oversight functions today. We are not simply debating an issue of national importance. This decision today is the exercise of public power, which demands of us to deal with this not based on our own political convictions or feelings, but in a manner that will uphold and defend the Constitution. A manner that will showcase obedience to the rule of law, the law which demands that only those who are fit and proper should be entrusted to serve as judges, and that in the event of a judge being found guilty of gross misconduct, we carefully consider whether such a judge remain fit and proper to retain that status. In this matter, the JSC has found that gross misconduct and has agreed that the only appropriate sanction would be removal from office. This finding and recommendation was, of course, House Chair, the product of a protracted process with which the JSC struggled to deal effectively and speedily. While it must be said to the JSC, or the small JSC then, as part of our national conversation, that the mere fact that it took 15 years to complete has seriously undermined the credibility of the JSC and by extension possibly even of the judiciary, it on the other hand, of course, can never be said that the matter was rushed. And more importantly, it cannot be argued that this report creates anything other than a constitutional obligation on us to support removal from office. This is the only reasonable and rational decision available to this National Assembly today. Speaker, die besluit wat ons as nasionale vergadering moet neem, stel ons voor bepaalde grondwetlike uitdagings. Sou ons toelaat dat ons politieke agendas en ons politieke verskille bepaal hoe ons besluit oor die moontlike verwydering uit die ampt van regter-president Hlophe, dan sal ons weer eens onsself blootstel aan geregverdigde klagtes dat ons versuim om in die uitvoering van ons take om getrou te bly aan ons land se grondwet. Die regterlike dienskommissie se feitebevinding en die gevolgtrekking dat die wangedrag van regter-president Hlophe so ernstig was dat die enigste gepaste straf is om hom uit die ampt te verwyder, staan vas en is die produk van 'n uitgerekte proses wat by 'n tye selfs die onderwerp van hofaansoeke was. Dis 'n harde realiteit waarby ons nie verby kan kyk nie. 'n Gebrek aan integriteit kan nie versoen word met die vereiste dat regters geskik en gepas moet wees vir die ampt nie. Daar kan nie plek op die regbank wees vir enige regter wat ander lede van die regbank onbehoorlik probeer beïnvloed in die uitvoering van hulle take nie. Getrouheid aan ons amptseed as lede van die parlement, laat ons dus, voorsitter, met geen ander keuse as die portefeulje komitee se verslag en aanbeveling te ondersteun nie. Dankie.
Thank you. The next speaker is the Honourable Ngola.
Thank you very much, House Chair, the Speaker of the National Assembly, the Deputy President of the Republic of South Africa, Ministers and Deputy Ministers present, members of the House, and fellow South Africans. There is an old saying that says, the robe magnifies the conduct. Its meaning is that judges must be held to higher ethical standards if they are to keep the trust and confidence of the people they serve. Holding judges accountable for their conduct can preserve public confidence in the judiciary. As has been alluded to, this process, which is defined in the Constitution, is an exercise of accountability. It is about ensuring that the rule of law is respected by even those who wield power. It is about ensuring that people have faith in the judiciary. The judiciary cannot exist without the trust and confidence of the people. Judges must therefore be held accountable to legal and ethical standards. The independence of the judiciary is a distinctive feature of a constitutional democracy and is an important feature of the doctrine of separation of powers. The Constitution demands that the courts remain independent, subject only to the Constitution and the law. As the branch of government that applies the law, it is important that the courts are able to apply it to the other branches of government too. This gives effect to the principle that no one is above the law, not even the most powerful figures in society. The terms of office of judges are defined and their security of tenure protected. Judges may only be removed from office in specific circumstances. Section 177 of the Constitution clearly spells out that a judge may only be removed from office if the Judicial Service Conduct Commission finds that the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct. So, judges are protected such that we are using a higher threshold, gross misconduct, not just misconduct. And you require 2/3 majority in the National Assembly for you to do that. So, Honorable, in addition to this, House Chair, I am being disturbed on my left. In addition to this,
honorable members,
the National Assembly must pass a resolution calling for the removal of that judge with a supporting vote of at least 2/3 of its members. After such a resolution is passed, the President must remove the judge, Honorable Nyonso. It's not optional. The law instructs that the President must remove the judge. In their wisdom,
order, honorable members.
I love you too, Mam Kaula. The drafters of our Constitution added these provisions to ensure that judges are not easily or arbitrarily removed from office for reasons politically, frivolous, and unrelated to judges' fitness to hold office. A fundamental aspect of judicial independence is impartiality, which is the idea that judges should interpret and apply the law with minds open to argument and free of bias. When hearing a matter, a judge should not have already decided the outcome before he hears all the sides. This principle is placed under threat if judges take their own personal allegiances, whether they be political, religious, ethnic, or arising from some other source, into account when adjudicating a matter. The institutional protection for courts' independence is provided by Section 165, subsection 3, and subsection 4, which ensures that no person or organ of state may interfere in the functioning of the courts, and that organs of state must assist and protect the courts to ensure their independence and the impartiality. The facts of the case of Judge President Hlophe have already been outlined by the chairperson and other members who debated before me. It is perhaps important to remind ourselves of the findings of the JSC. The JSC found that Judge Hlophe did not express abstract academic views about the law of privilege. He said that the SCA got the law wrong, and in the meeting with Justice Nkabide, there was no case against Mr. Zuma. In that context, he asked them both to decide the case correctly. The JSC agreed with the tribunal that to decide the case correctly, where Judge President Hlophe's view was that the SCA got the law wrong, could only mean overturning the SCA and thus finding in favor of Mr. Zuma. It found that was consistent with his admitted suggestion that Mr. Zuma was being persecuted. It further found that It also means that in saying Sesitembele Kunina, Judge President Hlophe conveyed his hope that the Constitutional Court, as the apex court, would correct the errors committed by the Supreme Court of Appeal. That is how Justice Jaffa understood the phrase, and how a reasonable observer would have understood it, by the way. The JSC found that Judge President Hlophe's conduct was in breach of the requisite objective standard. The JSC concluded that Judge President Hlophe's conduct constituted an attempt improperly to influence the two judges concerned, to threaten and interfere with the independence, impartiality, dignity, and effectiveness of the Constitutional Court, and breach the principle that no outsider, be it government, pressure groups, individual, even another judge conducts his or her case and makes his or her decision. It found that Judge President Hlophe's conduct fell short of the standard required of a judge, and that he had committed gross misconduct. On the question whether the National Assembly may reopen an inquiry, the Supreme Court of Appeal has already answered to this matter. The court clarified that it is the JSC which bears the responsibility of making a finding of gross misconduct. It further clarified that that is not the responsibility of the JSC to decide whether Judge President Hlophe should be removed from office, as that role belongs to the National Assembly. The court went on to clarify that National Assembly does not revisit the JSC's finding of gross misconduct. It takes a decision. At this juncture, the National Assembly is called upon to take a decision. The chairperson of the committee has demonstrated how the Portfolio Committee, as an extension of the National Assembly, applied itself to the JSC's findings. Judge President Hlophe was invited to place an extenuating circumstances that he considered relevant to the committee's deliberations as to whether his removal from office is appropriate response to the already proven gross misconduct. Hlophe JP was granted 2 opportunities to make extensive written representations, mindful, of course, that it was not facilitating an inquiry process. Regrettable, the arguments he raised were not convincing. House Chair, before a judicial officer begins to perform their functions, they take an oath or solemn affirmation of a judicial office that they shall be faithful to the Republic of South Africa, uphold and protect the Constitution, and entrench human rights, and administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. Justice Hlophe was appointed as a judge to the Western Cape High Court in 1995, and later as a judge president of the Western Cape Division of the High Court in 2000. Like other judicial offices, he took the judicial oath of office, swearing or solemnly affirming to uphold and protect the Constitution of the Republic of South Africa. Regrettable, the conduct of Judge President Hlophe fell below the standard required of someone in a position like his. Persons who assume the office of judge must work assiduously to manifest good character by demonstrating integrity in the detail of their life and their work, and the African National Congress supports this report. Thank you very much.
Well, thank you, Honourable Member. That concludes the debate. Order. I will now put the question. The question before the House is that the National Assembly resolve to call for the removal of Judge President M J Hlophe in terms of Section 177, subsection 1 of the Constitution of the Republic from office. Are there any objections? There are objections. I will now put the question. Those in favor of the call for the removal of Judge President M J Hlophe from office in terms of Section 177, subsection 1 of the Constitution of the Republic will say aye. And those against the call for the removal of Judge President M J Hlophe from office in terms of Section 177, subsection 1 of the Constitution will say no. I think the ayes have it. Are there any objections? Yes.
Chair, the EFF objects and we call for a division.
Thank you. Order, honorable members. Order. Honorable members, in terms of Section 177, subsection 1 of the Constitution of the Republic, a judge may be removed from office only if the National Assembly calls for the judge to be removed by a supporting vote of at least 2/3 of the members of the Assembly. Although a division has been demanded, we are reminded that all members are required to record their vote when the opportunity is given to them. Honorable member. Honorable member, do you want to leave the sitting? We are busy now then, but then you must abide by the rules of the sitting. Order. Honorable members, let me also bring to your attention that when voting on this question and the next question on the order paper, the members who are suspended from parliamentary activities will not be called upon during the roll call of the vote. These members are These members are the Honorable Malema, the Honorable Shavambu, the Honorable Dlamini, the Honorable Ndlozi, the Honorable Pambo, the Honorable Tambo, and the Honorable Peters. The bells will be rung for 10 minutes.
Okay.
Order, honourable members. Will you take up your allocated seats? Order, honourable members. I see there's still members at the back on both sides who are struggling to find their seats. Order, honourable members. We will now proceed. Honourable members, the rules of the National Assembly provide for different procedures for members to cast their votes. These include voting by electronic means or manual voting procedure by way of a whip or voice. The rules also stipulate that the Speaker must predetermine the voting procedure. For this division, the Honourable Speaker has determined that the manual voting system will be used, whereby each member will be called upon and requested to voice his or her vote. In terms of the rules, All members present when the question is put with the doors barred must vote or record an abstention. This rule does not apply to a minister or a deputy minister who is not a member of the House. Political parties provided a list of members who will be called first when it is their turn or their party's turn to vote. After that party's list has been called, the remaining members of the party will be called alphabetically. The Secretary will call each member from the membership list, starting with those from the majority party, and members will be called by their surname followed by their initials. In order to facilitate the process, I appeal to the honourable members to indicate their vote only, without a preamble, statement, and without delay. Members must thus simply indicate yes, no, or abstain. This will assist the table staff and the tellers in ensuring that your vote is correctly captured. In the event of a member's name is being called and they are present, but for whatever reason do not indicate their vote, an opportunity will be provided for such members to raise their hands after the last member is called from the list, at which point they will be recognized to cast their vote. Order. The question before the House is that the National Assembly resolve to call for the removal of Judge President M J Hlophe in terms of Section 177, subsection 1 of the Constitution from office. Those in favor of the call for the removal of Judge President M J Hlophe from office in terms of Section 177, subsection 1 of the Constitution will vote yes, and those against the call for the removal of Judge President M J Hlophe from office will vote no. Those who want to abstain will record their vote as such. Voting will now commence. The doors of the chamber will remain locked until the voting procedure is completed. The Secretary will now proceed to call members.
Majodina, PCP.
I vote yes.
Mashatile, SP.
Yes.
Mapisa Ngakula, NN.
I vote yes.
Sinodi, SL.
Yes, it's my vote.
Buroto, MG.
Yes.
Ntombela, MLD.
Yes.
Dlakude, DE.
Yes.
Tseki, GK.
Yes.
Khadebe, BA.
Yes.
Kele, BH.
Yes.
Chikunga, LS.
Yes.
Chrissy, BD.
Yes.
Didiza, AT.
Ewe.
Dlamini Zuma, NC.
Not here.
Absent. Godongwana, E.
Yes.
Godan, PJ.
Yes.
Gungubele, M.
Ewe.
Kivit, N.
Yes.
Kodwa, NG.
Yes.
Kubai, MT.
Yes.
Lamula, RO. Mantashe, SG.
Order, honourable members.
Mantashe, SG.
Yes.
Mtono, ES.
Yes.
Modise, TR. Mutsecha, MA. Mutsale, DPA.
Yes.
Ndabeni, Abrahams, ST.
Ewe.
Chabeni, KPS.
Yes.
Nxesi TWT,
Yes, sir.
Nzimande BE,
Yes.
Pando GNM, Patel E,
Yes.
Pasha MJ,
Yes.
Ramohupa ML, Zigalala S,
Yes.
Zulu LD,
Yes.
Bapela KO,
Yes.
Buotes A,
Yes.
Benz Namasha Z,
Ewe.
Kappa RN,
Ewe.
Lomo SM,
Yes.
Gina N,
Yes.
Olomisa SP,
Ewe.
Jeffrey JH,
Yes.
Kekana PS,
Yes.
Mafu WN, NN,
Ewe.
Mahlalela AF,
Yes.
Mahlobo MD,
Yes.
Majola FZ,
Yes.
Makwetla SP,
Yes.
Manamela KB,
Yeah.
Mangu LN,
Yes.
Mapulane MP,
Yes.
Mashiko Dlamini KC, Masondo D,
Yes.
Matale CC,
Yes.
Muhaule MR,
Yes.
Muloi BE,
Yes.
Murulong IK,
Yes.
Mutaung NE,
Yes.
Ngabane NP,
Ewe.
Nzuza NB,
Yes.
Pilane Make MCC,
Yes.
Squacha M,
Yes.
Sochu MM,
Yes.
Swartz B,
Yes.
Tau MPF,
Yes.
Tolashe NG,
Ewe.
Chabalala J,
Dikotenda, yes.
Chwete,
Yes.
Abraham PN,
Ewe that.
Adams RC,
Yes.
Adwons NG,
Yes.
April HG,
Extem, yeah.
Biokes AJ,
Yes.
Bilangulu JH,
Yes.
Bilangulu NK,
Yes.
Bongo BT,
Yes.
Butelezi NS,
Yes.
Kappa N,
Yes.
Chabane MS,
Yes.
Direko DR,
Yes.
Dlamini ME,
Yes.
Dlamini NE,
Yebo.
Dlamini SM,
Yes.
Dlulane BN,
Ewe.
Dunjwa ML, Janki QR,
Yeah.
Gancho N,
Yes.
Gela A,
Yes.
Gomba MM,
Yes.
Gumbu TT,
Yes.
Kumede SN,
Yes.
Hadebe BM,
Yes.
Hadebe KER, Harvard X,
Yes. Yes.
Hadebe KER, Harvard X,
Yes.
Hermans J,
Yes.
Hlongo AS, Jacobs F,
Yes.
Jacobs KL,
Yes.
Kumalo FE,
Yes.
Kibi MT,
Yes.
Kornov GW,
Yeah.
Kotampeko ZA,
Yes.
Kubeka NJ,
Yebo.
Likhwase TI,
Yes.
Lesoma RMM,
Yes.
Letsie WT.
Yes.
Lubengo ML.
Ndikotenda.
Luzipho S.
Yes.
Make JJ.
Yes.
Mabe BP.
Yes.
Mabiletsa MD.
Yes.
Magaxa KE.
Yes.
Magwanishe G.
Yes.
Mamehlala T.
Yes. Yes.
Mahlaule MG.
Yes.
Mahlo NP.
Kuyadumela.
Maumapelo SOR.
Yes.
Makata TZ.
Ewe.
Makubela Mashele LS.
Yes.
Makubele Marilele PP.
Yes.
Malati T. Absent. Okay. Malimacha CN.
Yes.
Malinga VT.
Yes.
Malomane VP.
Yes.
Mamabolo JB.
Yes.
Mananiso JS.
Yes.
Mandela ZMD. Absent. Maneli BM.
Yes.
Maneli ST.
Yes.
Manganye J.
Napfumela.
Marekwa GP.
Yes.
Maseko Jele NH.
Yes.
Masheko MR.
Yes.
Mashele TV.
Yes.
Masiko FA.
Yes.
Masondo TS.
Yes.
Maswale GP. Absent. Masuku MB.
Yes.
Masuta TM.
Ndiatenda.
Maswanganyi MJ.
Yes.
Matafa OM.
Yes.
Matebula EF.
Yes.
Matuba MM.
Yes.
Is that a yes? Is that a yes? Okay. We can't hear Matuba. Did Honorable Matuba say yes?
Yes. Yes.
Yes. All right. Mbata SGN.
Yes.
Mbingo Gigaba BP.
Yes.
Mbuyane SH.
Yes.
McDonald LE.
Yes.
Mchunu TVB.
Yes.
Mdabe SW. Absent. Mtakane MR.
Yes.
Mgweba T.
Yes.
Mjobo LN.
Yes.
Mkachwa NT.
Yes.
Mkize ZL.
Yes.
Mkwanazi JCN.
Yes.
Mlenzana Z.
Yes.
Memezi HMZ.
Yes.
Mutle TN.
Yes.
Moashe RM.
Yes.
Modise M.
Yes.
Modise PMP.
Yes.
New vote Gruchen WS.
Yes.
Moela DL.
Yes.
Molala LE.
Yes.
Molikwa MA.
Yes.
Monaketi MD.
Yes.
Morowane ML.
Yes.
Morwashesha PR.
Yes.
Motapo MRM.
Kuyadumela.
Motsecha MS. Absent. Mpanza TS.
Yes.
Mpumza GG.
Yes.
Mpushe PT.
Yes.
Msimango XN,
Yes.
Mula N,
Yes.
Mvana NQ,
Yes.
Myeni ET,
Yes.
Myolwa DJ, absent. Ndaba CN,
Yes.
Ngweng GN. Ngweng,
Yes.
sorry. My apologies. Nkomo Z,
Yes.
Nkosi BS,
Yes.
Nonsele M,
Yes.
Not Nachel J. Is it absent? Absent, okay. Ngola X,
Yes.
Dobongwana N,
Yes.
Ntuli MM,
Yebo.
Ntwane JC,
Yes.
Papo AHM,
Yes.
Patrin S, is that absent? Peacock NP,
Yes.
Pehle PA,
Yes.
Piri CM,
Yes.
Peterson ML,
Yes.
Pillay KB,
Yes.
Kaiso XS,
Yes.
Ramadwa MM,
A.
Ramoblobeng A,
Yes.
Siabi AM. Yes. Simenya MR.
Yes.
Shabalala LF.
Ngiyavuma.
Sibiya DP.
Yes.
Sihloayi NN. Absent. Siweya RT.
Yes.
Kosana GJ. Yes. Somyo SS. Yes. Stock DM. Yes. Klape MME.
Yes.
Klumeleng KB.
Yes.
Tobias TV.
Yes.
Tseki MA. Kiyadumela. Chwete B. Chwete B.
Yes.
Chobeka Makeke.
Yes.
NP. Van Skagweg SR. Van Skagweg SR.
Yes.
Volmarans MJ. Yes. Kaba NV.
I vote yes.
Kaba VC.
I vote yes.
Kaba Nchaba PP.
Yes.
Kasa FD.
Yes.
Kego ST.
Yes.
Yabo BS.
Yebo.
Zibula BT. Zibula BT. Absent. Zondi MA.
Yes.
Zuma AS.
Yes.
Zungu TRM.
Yes.
Zwane MJ. Zwane MJ absent.
Steenhuisen JH,
I vote yes.
Kwahube S,
Yes.
Lotriet A,
Yes.
Van der Walt D,
Ja.
George DT,
Yes.
Sarupian AN,
Absent.
absent, okay. Alexander WR,
Yes.
De Villiers JN,
Ek stem ja.
Bredenbach G,
Yes.
Horn W,
Ja.
Nodata BB,
Hoor.
Masango BS,
Yes.
Krumbok GR,
Yes.
Marais SJF,
Ja.
Kola D,
Yes.
Magloire JJ.
I vote yes.
Abrahams, ALA. Abrahams, ALA. Bargram, M.
Yes.
Basson, LJ. Bagman, D.
Yes.
Bodlani, T.
Yes.
Bryant, DW.
Yes.
Bond, MS.
Yes.
Chetty, M.
Yes.
Clark, MO.
Yes.
Cuthbert, MJ.
Yes.
Engelbrecht, J.
Ja.
Esak, F.
Yes.
Faber, WF.
Ja.
Golding, BC.
Yes.
Gondwe, MM.
Yes.
Graham, SJ.
Yes.
Halsey, T.
Yes.
Hickling, MB.
Yes.
Hansinger, CHH.
Yes.
Ismail, H.
I vote yes.
Joseph, D. Joseph, D. Absent. Absent. Gau, KL.
AM.
Kanyile, TA.
Yes.
Kumalo, NV.
Yes.
King, CV.
Ja.
Creer, HCC. Legov, TA.
Yes.
Lis, RA.
Yes.
Lorema, JRB.
Yes.
Mabena, TB.
Yes.
Mabika, MS.
Yes.
McPherson, DW.
Yes.
Majola, TR.
Yes.
Malati, MS.
Yes.
Maray, EJ.
Yes.
Masipa, NP.
Yes.
Matsone, NWA.
I vote yes.
Babama, TM.
Yes.
Mbele, ZN. Mileham, KJ.
I vote yes.
Moore, SJ.
I vote yes.
Mpiti, L.
Yes.
Myberg, NG.
Yes.
Ngobo S.
Yes.
Opperman G.
Ik stem ja.
Phillips C. Phillips C. Absent. Powell EL.
Yes.
Rose AC.
Yes.
Schreiber LA. Schreiber absent. Seitlolo IS.
I vote yes.
Sharif NK.
Yes.
Shelembe ML.
Yes.
Small JF.
Ja.
Spies ERJ. Absent. Stab DJ.
Ja.
Terry Blanche OS.
Ja.
Van Dijk V.
Ja.
Van Minen BM.
Yes.
Van Zeel AM.
Ja.
Walters TCR.
Ja.
Weber AMM. Weber MM.
Yes.
Whitfield AG.
Yes.
Winkler HS.
Yes.
Mente NV.
No.
Mautwe OMC. Absent? Okay. Mashabela NR.
No.
Mkalipi HO.
No.
Tlangwini EN.
A definite no.
Arias LH.
A definite no.
Keza K. Absent. Chirwa NN. Absent. Gerike V.
It will be no.
Shomvana KNF. Shonyana KNF. Kaula MS.
Tababo. Asvum.
Komane RN.
No.
Dichape MS.
No.
Madlingozi PS. Madlingozi PS. Mafanya WTI.
No.
Makamba Bokya N.
It's a no.
Makesini M. Absent. Manyi M.
No to selling out.
Marais P.
Near.
Matulelwa B. Absent. Matthias NS. Absent. Matumba A. Absent.
Indiko hana.
Matumba A.
Indiko hana.
Mhlongo N.
Ka. No.
Mkonto CN. Absent. Mkwebane BJ.
Definitely no.
Mukhale T.
No.
Muhlala MR.
There's a big no.
Muntwedi MK. Muntwedi MK. Absent. Mtetwa E. Absent. Noluchungu NJ. Absent. Paulson MZ.
No.
Shikwambana M.
No.
Siwisa AM. Absent. Sonti NP.
No.
Techana Y. Absent. Tembekwayo SS.
No.
Tito LF. Absent. Yako YN.
No.
Tabisa VF.
Yes.
Sing N.
Yes.
Butelezi EM.
Yebo.
Ngobo SL. Absent.
No. Yes. I'm not absent.
Okay.
Yes.
Tebekulu RN.
Yes.
Majozi Z. Absent. Butelezi SA. Absent. Shengwa MD.
Yes.
Shengwa M.
Yes.
Lutuli BN. Absent. Msimang City.
Yes.
Sitole KP.
Yes.
Van der Merwe LL. Absent. Zondo SS. Absent. Groenewald PJ. Absent. Mulder CP.
Ja.
Vessels WW.
Yes.
Boshoff WJ.
Ja.
Briet T.
Ja.
Denner H. Absent.
Ja.
Okay. Groenewald IM.
Ja.
May P.
Ja.
Melder FJ.
Ja.
Van Staden PA.
Ja.
Meshwe KRJ.
Absent.
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 Swart SN.
Yes.
Tring WN.
Yes.
Suckers ME.
Yes.
Olomisa BH. Absent. Kwangwa NLS.
Yes.
Zungula V.
No.
Mahau TL.
A big no.
Delil P.
Yes.
Heron BN.
Yes.
Sheikh Imam AM. Absent. Galo MP. Galo MP. Jafta SM.
Yes.
Lekota MGP.
Yes.
Luate T.
Yes.
Nyonzo M.
No.
Hendrix MGE.
No.
Order, honourable members. As I indicated earlier, members who remain present but could not, when called, indicate their vote may now raise their hands, after which I will recognize them to indicate their vote. The Secretariat will assist me in this regard. There's no indication. Thank you very much. The voting session is now closed. Order, honorable members. Order. Honorable members, the result of the division is as follows. There's no abstentions, 27 voted against, and 305 voted in favor. The question is order. The question is accordingly agreed to, and the House resolves to call for the removal from office of Judge President M J Hlophe in terms of Section 177, subsection 1 of the Constitution of the Republic. This resolution will be communicated to His Excellency the President. Honorable members, I now request the Secretary to read the last order of the day. Order, honorable members. Those who are leaving the chamber must do so in silence.
The second item for consideration reads as follows. Consideration of recommendation for removal from office of Judge N J Motata in terms of Section 177, subsection 1 of the Constitution.
Honorable members, I now call to the podium the Honorable Magwanishe, who will introduce this report.
Thank you very much, House Chairperson, His Excellency the Deputy President, Honorable Ministers and Deputy Ministers, Honorable Members. As we were building a democratic South Africa, we deliberately opted for a constitutional democracy, understanding the injustices, sufferings, and brutality caused by the colonial and apartheid systems. We chose a constitution which is founded on human dignity, the achievement of equality, and the advancement of human rights and freedoms. We chose a constitution which is founded on non-racialism and non-sexism, on the supremacy of the Constitution, rule of law, multi-party system of democratic government to ensure accountability and openness. Our Constitution creates a law-governed society which will be inimical to arbitrary rule. The Constitution we adopted clearly states that, and I quote, "We the people recognizes the injustices of our past and believe that South Africa belongs to all who live in it, united in our diversity," close quote. We adopted the Constitution to build a united and democratic South Africa. When taking office, judges swear or solemnly affirm to be faithful to the Republic of South Africa, to uphold and protect the Constitution and human rights entrenched in it, and to administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. When a person takes an oath or solemn affirmation, he or she does so on their word of honor. It is binding on their conscience. In the early hours of the 6th of January 2007, Justice N J Motata, whilst driving, reversed into the boundary walls of a residential property. In the course of those events, Motata J became involved in a verbal altercation with the owner of the property. During the confrontation, Motata J reportedly used racial slurs, profanities, and language of derogatory nature, all of which was recorded. When two female officers of the Johannesburg Metropolitan Police Department arrived at the scene, Motata J refused to cooperate with them. When one of the officers, a woman, informed him that she would arrest him, he responded that he would not be arrested by a female officer. Eventually, he was arrested. Motata J was subsequently charged with 2 counts of criminal misconduct, that of contravening Section 65, subsection 1A of the National Road Traffic Act of 1996 by driving a motor vehicle under the influence of alcohol, and contravening Section 67, subsection 1A of the South African Police Services Act of 1995 of defeating and obstructing the ends of justice by resisting arrest. The trial court was satisfied that given Judge Motata's proven speech, physical and mental impairment, and his general conduct shortly after the collision, the only reasonable inference was that Motata J was indeed under the influence of intoxicating liquor at the time that he drove his vehicle into the wall. Judge Motata appealed against his conviction to the full bench of the Gauteng Division of the High Court. The appeal failed. On 29 November 2010, the appeal court confirmed the conviction. The appeal court found it extremely improbable that any High Court judge in his or her sober senses would use the kind of foul language used by the appellant in the presence of unknown members of the public and police officers, some of whom being women. Judge Motata instituted legal proceedings on technical grounds to challenge aspects of the JSC Act. This challenge, too, was ultimately unsuccessful. Section 177 of the Constitution provides for the removal of a judge, setting out a three-stage process as follows. A judge may be removed from office only if the Judicial Services Commission finds that the judge suffers from incapacity, is grossly incompetent, or is guilty of gross misconduct. The National Assembly calls for that judge to be removed by a resolution adopted with a supporting vote of at least 2/3 of its members. The President must remove the judge from office upon adoption of a resolution calling for that judge to be removed. The Judicial Conduct Tribunal recommended to the JSC in 2018 that Judge Motata be removed from office for gross misconduct. However, the JSC refused to accept the recommendations, deciding Motata J's actions at the time of the crash amounted to misconduct rather than gross misconduct and did not warrant his removal from the judiciary. Instead, it fined him 1.1 million, which he paid to South African Judicial Education Institute in compliance with the judgment. In 2010, an organization called Freedom Under Law began proceedings before the Johannesburg High Court to have the JSC decision reviewed and set aside, and to substitute that decision with a finding that Motata J was guilty of gross misconduct. The High Court dismissed the application in 2022, prompting Freedom Under Law to apply for leave to appeal to the Supreme Court of Appeal. The Supreme Court of Appeal rejected the JSC's findings that Judge Motata was not guilty of gross misconduct and upheld the Freedom Under Law. The matter was remitted to the JSC, which made the finding of gross misconduct. The matter was referred to the Portfolio Committee for consideration and report on the 25th of August, 2023. Regarding the procedure to be followed, the committee noted the clarity provided by the Hlophe judgment on the specific roles assigned to the JSC and the National Assembly in giving effect to Section 177 of the Constitution. The committee developed steps to allow for sufficient engagement with the affected judge and deliberations to empower its members to make an informed political decision about the remedy determination as a consequence of the JSC findings. A court clarified that the National Assembly role is not to rehear the matter, as that is a question of merit already settled at the JSC finding stage. In making its determination, the National Assembly makes a political decision. The committee wrote to Motata J in a letter dated 4th October 2023, inviting him to place any extenuating circumstances that he wished the committee to consider when it deliberates on the matter. The committee had agreed that the representation should be in writing only and should reach it by the 27th of October 2023. In reply, the committee received a letter from Motata J dated 12 October 2023, requesting that he be given until 30th of November 2023 to submit his written representation to the committee. The committee agreed to give Motata J until 15th November 2023 to do so. The committee received further correspondence from Motata J dated 10th November 2023, in which he raised the following arguments. The JSC did not make any decision which could be referred in terms of the JSC Act to the National Assembly for further processing for purposes of Section 177 of the Constitution. He argued that absent of a clear finding of the JSC, the National Assembly, and by implication the committee, lacked jurisdiction to entertain the matter. And if the National Assembly nevertheless entertained the matter, such steps would amount to double jeopardy, as Motata J had already paid a fine to Sajay in compliance with the prejudgment misconduct finding of the JSC. The committee then wrote to the Chief Justice requesting that the JSC clarify the issues raised by Motata J, namely whether it indeed regards the SCA ruling of gross misconduct as having been made the decision of the JSC, which was then referred for consideration to the National Assembly. The Chief Justice replied in a letter to the Speaker of the National Assembly, in which he attached the resolutions of the meeting of the JSC, sitting without members of the National Assembly, dated 17 November 2023. The small JSC confirmed that it regards the order of the Supreme Court of Appeal as effectively setting aside the JSC's previous misconduct finding against Judge Motata and replacing it with a finding of gross misconduct. It is this finding of gross misconduct against Judge Motata that has been referred to the National Assembly. Regarding the argument of double jeopardy, the committee held a view that it was an issue to be resolved between the JSC and Motata J and did not prevent it from proceeding with the deliberations. Racism and sexism are not something to be taken lightly, wherever they flow from. They are a reminder of our painful past and an antithesis of our very Constitution, which judges make an oath to obey. The removal of a judge is not an opportunity for jubilation. It gives us an opportunity to reflect as a nation. It is about accountability, ensuring adherence to judges to their oath of office. This process is about instilling faith in the judiciary. The public must have trust in those who dispense justice to them. Article 5.4 of the South African Judicial Conduct articulates that judge must always, not only in the discharge of official duties, act honorably, in a manner befitting judicial office. Public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy founded on the rule of law. The court described Judge Motata's conduct as egregious and that his behavior at the scene of the incident was characterized by racism, sexism, and vulgarity. It went on to say, the public watched him conduct a dishonest defense during his trial and on appeal. They watched him dishonestly accuse Mr. Bate of using the K word, only thereafter withdraw the accusation. They watched him lie under oath to the tribunal about his level of intoxication, as the videos of him slurring his words and stumbling went viral. It held that his conduct is inimical to his office and that as long as he is entitled to be called Judge Motata, the judiciary continued to be stained in the eyes of the public. The Portfolio Committee on Justice and Correctional Services, having considered the referral by the Chief Justice of the Republic of South Africa of findings of gross misconduct against Judge Motata in terms of Section 20, subsection 4 of the Judicial Services Commission Act of 1994, read with Section 177, subsection 1 of the Constitution of the Republic of South Africa, recommends that the National Assembly resolve to call for the removal of Judge Nkola Motata from office.
Thank you very much, Honorable Magwanisha. The next speaker is the Honorable G. Breitenbach.
Honorable House Chair, honorable members, The impeachment of Judge N J Motata stands as a significant beacon in the history of South Africa's judiciary, shedding light on the imperative of maintaining judicial integrity and accountability. This very important debate has broad and far-reaching importance and implications for our legal system. No sitting judge has ever been impeached in South Africa prior to today. The fact that we are having this debate is a testament to our Constitution and the fact that we as a democracy are mature enough to be having this debate. The importance of judicial integrity cannot be overstated. By way of background, Judge Motata, a respected figure within the South African judiciary, served as a judge in the Gauteng Division of the High Court. He enjoyed the respect of his peers and of the legal profession. The allegations against him stem from an incident in 2007 when he was involved in a car accident while blind drunk. Who can forget the photographs of the judge slumped drunkenly over his steering wheel, halfway through the wall of a private individual? Subsequent recordings of racially charged and sexist remarks made by Motata at the scene further exacerbated the controversy. These allegations raise serious questions about his fitness to hold judicial office and cast doubt on his ability to uphold the principles of impartiality and fairness. The legal framework surrounding impeachment proceedings against judges in South Africa is governed by Section 177 of the Constitution, along with the Judicial Services Commission Act, which outlines the process for investigating complaints of judicial misconduct. The Act is designed to uphold the integrity of the judiciary and ensure accountability amongst judicial officers, providing a mechanism for addressing allegations of misconduct in a fair and transparent manner. The impeachment process faced its fair share of challenges and controversies, including legal technicalities, procedural disputes, and public scrutiny. It required the intervention of civil society and freedom under law under the stewardship of Justice Hlophe to get us here today. The handling of the case raised questions about the effectiveness of the judicial disciplinary mechanisms and the broader issues of judicial accountability in South Africa. Moreover, there were concerns about the impact of the proceedings on public trust and confidence in the judiciary. The impeachment of Judge Motata carries significant implications for judicial integrity in South Africa. It underscores the importance of upholding the highest ethical standards amongst judicial officers and holding them accountable for their actions. It reaffirms the principle that judges are not above the law and must be subject to scrutiny and discipline when their conduct falls short of the expected standards. Furthermore, it highlights the critical role of public trust and confidence in the legitimacy of the judiciary. Sadly, Judge Motata let himself and all of us down rather badly. Instead of conducting himself with dignity, honesty, and humility, all traits that are necessary to make a judge worthy of that high office, he chose the path of lies and obfuscation, and in the process did great damage to the image and integrity of the judiciary as a whole. By doing so, he destroyed his own reputation and his legacy. The time it took to deal with this matter plunged the JCC and the JSE into disrepute. All in all, the entire process has wreaked an enormous amount of damage on the judicial system. The process, such as it was, leads to lessons learned for the legal community and society at large. It underscores the need for robust mechanisms to address allegations of judicial misconduct promptly and effectively. It also fixes the attention on the appointment process, underscoring the qualities that are required of prospective judges. In conclusion, the impeachment of Judge Motata reflects South Africa's commitment to upholding the rule of law and preserving the integrity of its judiciary. While the process was challenging and contentious, it ultimately reaffirms the principles of accountability, transparency, and judicial independence. Moving forward, it is essential to learn from this experience and strengthen the mechanisms for safeguarding judicial integrity in South Africa, ensuring that judges uphold the highest ethical standards and remain accountable to the citizens that they serve. Judge Motata failed to live up to and uphold these requisite standards, and in voting to impeach him, we as Parliament will be underscoring the essential need for high ethical standards required from those who aspire to sit in judgment of others. We support the recommendation of the committee.
Thank you very much, Honourable Member. The Advocate, E.J. Mkwabane.
Thank you, Chairperson. We wish to state that Section 277, in fact, Section 177 of the Constitution, provides inter alia that the judge may be removed from office only if the Judicial Service Commission finds that the judge suffers from an incapacity is grossly incompetent or is guilty of gross misconduct, and the National Assembly is called to remove that judge by a resolution with the support of at least 2/3 of its members. Chair, Section 20, subsection 3 of the JSC Act requires the Commission to make a finding as to whether or not the respondent is guilty of gross misconduct. Section 20, subsection 4 of the JSC Act provides, if in similar terms to Section 177 of the Constitution, that if the Commission finds that the respondent is guilty of gross misconduct, the Commission must submit that finding together with the reasons thereof and a copy of the report, including any relevant material of the tribunal, to the Speaker of the National Assembly. What is clear from the provisions referred to above is that it is the Commission and not the court or any other forum which is constitutionally and statutorily authorized to make a finding that a judge is guilty of gross misconduct, and that has the power to refer its finding to the National Assembly for appropriate action in terms of the Constitution and the Act. As stated here under and expressly supported by the letter from the Chief Justice, the Judicial Service Commission never made any finding of gross misconduct against Judge Motata. Furthermore, as also stated in the letter of the CJ, the SCA did not specifically set aside the finding made by the JSC in its sitting when it found that Judge Motata was not guilty of gross misconduct, but guilty of misconduct. Moreover, the CJ in his letter emphasized that the JSC did not itself make such a finding. This makes it abundantly clear that to date, there is no finding of gross misconduct by the JSE as required by Section 20, subsection 3 of the JSC Act, read with Section 177(1)(a) of the Constitution. Consequently, there is no jurisdictional basis for the present debate and referral. In the circumstances, the National Assembly, absent a finding made by the Judicial Service Commission as required by both the Constitution and the JSC Act, lacks the jurisdiction and or competence to entertain this matter. Taking this into account, the National Assembly is now endorsing a deeply unlawful and unconstitutional finding against Motata. Just like Judge Hlophe, Judge Motata was subjected to 2 processes, simply to find him guilty and to impeach him. He was fined an amount of 1,152,650 rand 40 cents, which he was ordered to pay to the South African Judicial Education Institute, and he paid that amount. Honorable members, we must all refuse to be used as pawns by racist institutions like Freedom Under Law, whose sole purpose is to hound black professionals. Judge Motata is already retired. Indeed, as the EFF, we don't condone racism, we don't condone women abuse and sexism, definitely, but can we then let Judge Motata, in his misjudgment, in that particular process, be left to enjoy his retirement at home? I mean, he's an old age person now. Let him retire at home. Can we leave him alone? The EFF doesn't support this removal. Thank you.
Thank you very much, Advocate Mkhwebane. IFP, the Honorable Singh.
Thank you very much, Honorable Chairperson and colleagues. Indeed, a very sad day again for South Africa and for this Parliament when we have to consider another judge for impeachment. I think it was hard enough to consider the other matter, although I noted that there was a 75% majority of this House when the votes were counted. But having said that, Honorable Chairperson, and as I said before, when the higher the office, the more the responsibility. And I think it's Honorable President who stood here the other day and said, the higher the office and the wind catches you more, the trees. So it is very sad that, now I got nothing to do with Palapala, and I will debate that on another day. It's very sad as well that this matter started in 2007, and it's 17 years later when it is being considered by us. And I think as much as we say to judges and others that there needs to be swift justice, we ourselves as Parliament and in the whole legal process, we need to ensure that there is swift justice in a matter like this and other matters. I think it's common cause that the rantings and ravings of the Honourable Judge is really not becoming of a person who holds such high office. And, to have allegedly accosted female members of the police, it makes the matter even worse. But since I've got this platform, Honourable Chairperson, I think whilst we look at interference within the judiciary by judicial officers, we also got to make sure that there's no political interference with the judiciary. And of late, we've been reading some reports, whether true or not, of certain political interference in the work of the judiciary. And I think this is something that we need to look at seriously as Parliament as well. But what we are doing today, I think, is sending a strong signal to judicial officers that their ethics have to be above board. I don't see Honourable Lamola here because I would have told him this, but I think the Deputy Minister of Justice is here. I read the other day, and I can't remember the court, where there were allegations of corruption between the judicial officer, the prosecutor, the police, and everybody else, somewhere, I don't know if it's Palm Ridge or elsewhere, and I hope that you would investigate that matter expeditiously, because all these things that happen, within the judiciary undermine the judiciary and undermine our faith in the judiciary. We will support this report. Thank you, Chair.
Thank you, Honorable Singh. The Honorable Dr. Mellor. The Honorable Dr. Mulder.
Thank you, Honourable Chairperson. We all know that after the question of state capture, the credibility of Parliament also was questioned because of our role with regard to oversight and accountability. But lately, end of last year and now in the beginning of this year, I think Parliament is regaining its stature because of what we have been doing in terms of what is expected of Parliament. And I think that's a good thing, and I think it will send a good signal to the public and the electorate out there as we go into an election year. Last year we had to deal with the impeachment of a public protector, and today we are dealing with the impeachment of 2 judges. Now, with all due respect, I think colleagues in the House this afternoon had the opportunity to see what we on the ad hoc committee had to endure during the hearings on the former public protector. I think you get some kind of idea of what we had to endure for more than a year. We listened to the Honourable Mekwabane from the EFF. Not a word about the merits, not a word about the facts in this case, trying to pick up small little technical legal points to try and put her position.
Order, honourable members. Order, honourable members. Honourable members, give him a chance to complete.
Thank you, Chair.
Honourable Dr. Melder, could you please take your seat? There's a point of order. What's your point of order, honourable member?
Thank you, House Chair. We were not going to be told by some racist on how to speak and what to speak in our speeches. We'll speak it on how we want to speak. That is our minutes. We're not going to be told by him.
Honourable Ntangweni, that is not a point of order. And we have made a very desperation remark. Honourable Ntangweni, you have made a very uncomfortable remark that Dr. Melder is a racist. That is totally unacceptable. And I would like you to withdraw that. Please withdraw that comment, please.
Can you tell me which comment is it, House Chair?
That Honourable Melder is racist. It's not allowed.
I said we're not going to be told by a racist. I didn't say he's a racist.
He is the one on the platform. Honourable Ntangweni, Could you please withdraw what we have said? Honorable Ntlangwene, I am requesting you to stand up and withdraw what you have said. Honorable Ntlangwene, for your benefit, can I read Rule 84 for you? No member may use offensive, abusive, insulting, disrespectful, unbecoming, or unparliamentary words or language, nor offensive, unbecoming, or threatening gestures. You have just called Dr. Mulder a racist, and I am saying that is unparliamentary. Could you please withdraw that? Honorable Ntlangwene, you seem not to be responding. If you do that, you leave me with no option but to request you to be removed from the House. I will have to leave the House. If you're not going to do what I'm asking you to, I'll request you to leave the House. Honorable Ntlangwene, could you please leave the House? Sergeant at Arms, could you please help Honorable Ntlangwene out of the House? Could you please assist her to leave the House? Thank you very much. Honorable Mente, I see your hand is up. What is your point of order?
Yeah, Chair, if you are going to run the House like that, you are going to be wrong. You seem to hear what white people are saying, but you don't hear what the white people are saying about black people. Mkhwebane was just patronized by that white man standing there. You did not say anything. But when we talk about him, you hear things. We're going to have a problem. And we're not going to be run like that and be patronized by white people. Not in this South Africa, not in this House. You can continue to impeach black people, even those that are on retirement. Because of your Stellenbosch instruction, we don't care. But we are not going to be told by white people how to speak. You can be told, not us.
Honorable Mente. Honorable Mente. Honorable Mente. Your comments are totally not acceptable. Please don't do that again. Just allow the honorable member to continue. Honorable Mulder, you still have 2 minutes and 43 seconds to continue. And order, honorable members. Honorable Mulder, I see a hand at the back there. What's your point of order, honorable member?
Thank you, House Chair. House Chair, I just want to confirm something with you. You must confirm it with us. The honorable member on the platform is the son of a former minister during apartheid
Honorable
regime.
member, that
He
is
was
not
a
a point
member
of
of
order.
parliament under
Please,
apartheid regime.
take
A
your
son
seat.
of a racist is a racist. A son of a
Honorable
snake is a
member,
snake.
take
A dog
your
gives
seat.
birth to dogs.
Honorable
Therefore, he's
member.
the son of an apartheid racist. Himself, he was an MP in 1988 during apartheid. What does it make him to be? Tell us.
Honorable member, your disparaging remarks are not assisting. You are totally not assisting. Yeah. Honorable Msongo. Honorable Msongo has just defied the ruling that I made. I made a ruling on this matter. Honorable Msongo stands up to shout it and continue doing what she was doing. Honorable Msongo. Honorable Msongo, I will request you to leave the house. Because your intention was clearly to defy the please leave the house. Honorable Msongo, I request you to leave the house. Rule 17. You are ordered to leave the house for having defied. I made the ruling. You did what you did. Please leave the house. Honorable Sergeant at Arms, please help her to leave the house. I will repeat, I have made a ruling on this matter. I'm not going to make a ruling again. I've done with it. I'm not going to allow any hand. Honorable Kalipi, please put your hand down. I'm not going to entertain anything on this end. You can continue, Honorable Dr. Mulder.
Thank you, Chairperson. The idea in Parliament is that you're supposed to debate. That is what Parliament is about. So if somebody makes a point, you are supposed to be entitled to interact and to debate with regard to the actions. If you don't like what I'm saying, that's not my problem. I can't help you. But the move that you've made now from the EFF was not a very wise move. In the last vote, you only had 27 votes. Now you're going to have only 25 votes. You are moving backwards.
Honorable
with all
Mulder.
due respect. Yes, sir.
Please address Honorable Mulder. Can I address you? Please focus on your speech and do not address those members.
I will not address those members. Thank you, sir. The fact of the matter is, Chairperson, the unfortunate situation in this whole process was, and I think it's good for Parliament, but the unfortunate situation was that these matters were dragged out for so very, very long. Just look at the specific issue that we have at the moment. For almost 10 years, Judge Motata did not be able to work. He was on leave, but he received his benefits. He's been on pension now for more than 7 years. Costs for the taxpayers, unfortunately, because this whole matter was dragged out in such a way. And I think that's unfortunate. I think we should we should understand that that is not the way that these things should be dealt with. But I think the most important thing is that a clear message was sent. Nobody is above the law. Parliament is regaining our position in terms of playing the role as the legislative arm of the state, that the authority of Parliament should be respected, and hopefully, when we go into the election, the electorate will also deal with members who should not be in Parliament. Thank you very much.
Thank you very much. Honorable members, may I have your attention, please? May I have your attention, please? Honorable Mentor, may I have your attention, please? Honorable members, I would like to read Rule 10 to you. A member who willfully fails or refuses to obey any rule, order, or resolution of the House may be found guilty of contempt of Parliament in terms of the Powers and Privileges Act of 2004. So, honorable members, I am not going to tolerate it. I'm not going to accept the chaos that is ensuing here. What is your point of order, Honorable Mentor?
Chair, your table staff seems to be sleeping. The first thing you go to, you say the member must leave the House without asking the member to withdraw. Had you have done that, the member would have explained to you that she had a question.
Honorable
that
Mentor.
A beneficiary of apartheid was a racist. Is he not a racist now?
Honorable
That was
Mentor.
the question to you.
Honorable
Do not evade
Mentor.
the question and chase people out.
Honorable
Follow
Mentor.
your own rules.
Honorable Mentor. Honorable Mentor, please. I have made a ruling on that. If you are not happy,
You cannot not follow your own rules.
If
you
you are
must
not-
follow your own rules.
if you are not happy with the rulings that I made,
Follow
you know
your
what
own
to
rules.
do. Could you please take your
The
seat?
ANC caucus.
Honorable
committee,
Mentor,
that I
could you
must repent
please
you
take
to.
your seat?
Yes.
Honorable Mentor, could you please withdraw that what we have just said now? Withdraw what we have just said now. The manner in which you said it. Could you please withdraw it? Honorable Mentor, could you please withdraw your statement? Honorable Mentor, your intention apparently is to defy the chair. That's exactly what you're trying to do. Could you please behave?
Chairperson, my hand is up.
I will.
Chairperson, my hand is up. We ask uzwa-ke manje.
I'm still talking to Honorable Mentor. Could you please put your hand down?
I want to put an order.
Just put your hand down.
But
I'm not.
I want to assist
Could
you.
you please? I don't need your assistance.
But you are sleeping in your job.
I don't need your assistance. Honorable Mentor, clearly, the manner in which you're speaking is clearly intended to undermine me, and I'm not going to accept it. It is, yes, you are undermining the chairperson. You are undermining the chairperson, that's what you are doing. It is for that reason I'm asking you to withdraw what you are saying. You can't use words like bohai suga. Please, you can't. You cannot be doing that, Honorable Mentor. I want you to withdraw that. If you do not want to withdraw, Honorable Mentor, you're also leaving me with no option but to request you to leave the House. So I want you to withdraw that. Then if you refuse, please leave the House.
You can be left with your caucus.
Can I talk now?
I haven't recognized you.
Recognize me then.
I haven't recognized you.
Then recognize me.
Put your hand down. I haven't recognized you.
Never.
Honorable Zagota.
But my hand is up before Honorable Jagute.
Honorable Zagota.
But this is unfair, Chair.
Honorable Zagota.
Chairperson, this is unfair.
I will Honorable Zagota. I will recognize you. Let me just deal with this. Honorable Hlophe.
Yabona Chairperson. Honorable Mente, she speaks here. She asks you, she explained to you. Now we are saying that she must leave the house. Where now we have a duty to explain to members what is the reason for her to leave the house. If you are failing to be here as the chairperson, just tell us. We can all of us leave the house.
Thank you very much.
Which rule are you chasing Honorable Mente away? Can you quote the rule? That says she is prohibited to say hi suka.
Honorable Mente.
Just quote the rule. Can we have the rule? Because you can't chair the house with common sense. Use the rule of parliament. Which rule does not allow a member to say hi suka? Just read me a rule.
Honorable Hlophe, I have made a ruling.
Which ruling?
And I'm going to request you not to undermine the authority of the House.
But I'm seeking a clarity, Chair, in terms of the rules. You chase the member of this house on the basis that she said hi suka. I'm saying to you, it's you as the chairperson who must tell us which rule that prohibits a member of parliament to say hi suka. That is very simple.
Honorable Hlophe, I'm not prepared to converse with you. Could you please take your seat?
Because you hate EFF with passion. And you are failing to understand that after May, we are not coming back here. When?
Honorable Hlophe.
Awubuyi.
Honorable Hlophe. Honorable members, put your hands down, please. Put your hands down. Honorable Hlophe.
Awubuyi.
Stop what you are doing.
Njengegama lakho umadala, and you are very old to chair this house. That's why you can't even read the rule that says a member can say hi suka.
Honorable Hlophe, could you please leave the house?
Thank you
I'm removing
very
you.
much.
Get
You are
out
going
of
to
the
leave
house.
all of us because
Yeah.
we can't be here on this mediocre as the chairperson.
Leave the house. Honorable Hlophe, leave the house. Honorable members, shall we continue? Just put your hands down. Honorable Zagota.
Thank you very much, Honorable House Chairperson. I stand on a point of procedure. No member is allowed to have a microphone before they are recognized. That's one. And the matter that we are dealing with right now is the debate on the issue of Judge Motata. Can we please proceed? Please, Honorable House Chairperson, don't engage with any member. Let's focus on what is before us as members of the National Assembly. I thank you.
Thank you very much. I'm sure that is very clear. Shall we continue, honorable members? From the SADP, the Honorable Swartz.
Thank you, House Chair. House Chair, whilst the highest standards are expected of a judge, failure to meet those standards will not of itself be enough to justify the removal of a judge. So important is the judicial independence that the removal of a judge can only be justified when the shortcomings of the judge are so serious as to destroy confidence in the judge's ability to properly perform all the judicial functions. The ACDP believes this is a very high bar that is set, and that this bar has been attained in this case. And that particularly when one considers what the Supreme Court of Appeal said. It stated, public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy and founding on the rule of law. A fair-minded and dispassionate observer is bound to conclude that Judge Motata cannot properly discharge his functions. Now, the Honorable Magwanisha read at length of the conduct that was committed on that night. And that conduct was found and set out in this judgment. And the judge says, the conduct that I've been at pains to describe is of such a gravity as to warrant a finding that Judge Motata be removed from office. There is no alternative measure to removal that would be sufficient to restore public confidence in the judiciary. And I think that is very significant. It relates to the integrity of the judiciary and what we all witnessed that night. And it is a sad fact that it has taken so long to reach this point. And so the ACDP agrees with the Supreme Court of Appeal finding. It agrees with the deliberations that took place at length in the Portfolio Committee and agrees and supports this report. But what is also very significant is, and that we as Parliament need to bear in mind, is that both the majority report and the minority report had quite a lot to say about the conduct of the Judicial Service Commission as well in this whole matter. For example, the minority judgment in the SCA said it was disconcerting to witness a respected body like the JSC comprised of judges and legal practitioners from both the bar and the sidebar, and I'm a member of the sidebar as an attorney, and law professors being found wanting in procedural matters of their own institution. And that's the small JSC again. Members of Parliament are not involved in that. And I think that this is a matter for us just to bear in mind that there are, and the comments were made earlier as well. So these are issues that we need to look at, and I trust the Judicial Service Commission will also look at this judgment and improve its mechanism. The ACDP supports this report.
Thank you very much, Honorable Swart. The Honorable Kwankwa.
Difficult and very complex as the matter of Judge Motata is, given the fact that there were various decisions, misconduct, gross
Honorable
misconduct.
Kwankwa.
Yes.
Honorable Kwankwa, could you please take a seat? There's a point of order, but I need to mention it. I have made a ruling on all the chaos that took place there. I'm not going to entertain anything again from that. I'm definitely, it should be something all totally different. What is your point of order, Honourable Member? And
Yes. House Chair, I rise on a point of order, and the point of order is to understand the rules of this House and also your ruling.
Honourable Member,
Yes,
that
sir.
is not a point of order.
It
Could you
is
please
important.
take a seat?
It's important for us to understand your rulings.
Could you please take your
It
seat?
is also important for the public to understand your rulings. Are you making a ruling on a perception
Honourable
that somebody
Veza.
is defying your authority?
Honourable
Because this
Veza.
is exactly what you've done in the case of
Honourable
MP
Veza, please.
Mente.
Please stop what you are doing.
It's a perception. No, I can't stop because I need to have clarity on this.
It is.
You made a ruling on a perception, based on a perception, that somebody is defying your authority. And it cannot be right. And I
Honourable.
want you to answer me on this, sir. I approach you respectfully. We cannot be intimidated by the masses of the ANC. You had your chance for 30 years. You've messed it up.
Honourable Veza, I will go back to Rule 70 again. I will go back to Rule 70 again. If the presiding officer is of the opinion that a member is deliberately contravening a provision of these rules, or that a member is disregarding the authority of the chair as you are doing, or that a member's conduct is grossly disorderly, or he or may be ordered the member to leave the house, and that is what I'm asking you to do. Mr. Visual, please leave the house. Honorable Kwankwa, you may continue.
Well, Chairperson, I've even forgotten what I wanted to say. I'm kidding. Chairperson, we're saying, yes, we admit that the matter surrounding Judge Motata is a bit complex in the sense that, firstly, it was misconduct, and then later on it was gross misconduct. But that doesn't take away from the gravity and the seriousness of his offense. And for us, the decision we took earlier, including this one now, is about restoring public confidence in the judiciary. If we impeached Judge Hlophe earlier to do that, and there are recommendations and processes that have been followed to try and ventilate this issue properly, I now decide to call them legal ping-pongs because they take 15, 20, 30 years. They make for interesting reading, but the challenge is that we are not then in a position to resolve matters speedily, so that even those who deserve to get justice do get justice in the end. And I thought, my understanding is that we have judges for life, don't we? So they need to uphold those ethical standards for the entire period, for as long as they are paid by the taxpayer, whether retired or in office, to perform functions for the state. So if you happen to have retired, it's a pity, it's unfortunate, but now we have to sanction you because for us, you are a judge for life, not a judge for that particular period when you're in office. The United Democratic Movement supports the recommendation to remove Judge Motata. Thank you.
Thank you very much, Honorable Nkwa. The Honorable Maseko Chele from the ANC.
Thank you, Chairperson. Chief Whip of the Majority Party.
Honorable Chele, could you please take a seat? There's a point of order from the Honorable Manyi. I can't see you. I've noted you. Okay, I've noted you. Honorable Manyi, I've noted you, Honorable
Thank you,
Zulu.
Chair.
I've noted you, Honorable Zulu. Honorable Manyi.
I'm not rising on a point of order. This is actually the point. I'm rising on a point of privilege. Chair, the point I want to make is this, that when you've made a ruling,
Honorable
and
Manyi.
people continue, can I just make my point, Chair, first?
Honorable
Can I just make
Manyi.
my point?
Honorable
When you've
Manyi.
made a ruling, Chair, and
Honorable
people
Manyi.
keep raising their hand,
Let me warn you.
you cannot continue.
Honorable
You cannot
Manyi.
assume that the people want to raise the same
Honorable
issue.
Manyi.
Don't make assumptions when people raise their hands,
Honorable
Chair.
Manyi,
That's
I
the only
don't-
point I want to make.
I
Don't make
want-
assumptions.
I don't want any assistance from you. I don't even value it. Please. Honorable Zolo.
No, thank you very much, Chairperson. It's very unfortunate that you didn't see my hand earlier on, but I respect your rulings that you have made. I just want to ask that under Rule 69E, the previous member of the EFF, when he left the room, I don't know his name and I apologize. He did something that is really, really unacceptable. As he was walking up, you better shut up, man.
Honorable Zolo, please address me. Address me.
Yeah, as he was walking out, he showed this sign.
Okay.
He showed this sign
to you.
Thank
And
you.
you must bring the recording and you must see what it was and make a ruling. Also, Chairperson, on the same matter under Rule 69, as I said, I think we've got, please help us because it's clear that there are members who have decided they are going to disrupt throughout. So let's not be wasting time over them. We plead with you to make the ruling because clearly they don't want us to finish
Thank you.
what we are here for.
No. We will visit Hansard and deal with that later on. There's a hand at the back there. There's a hand at the back there. Honorable Papa. Is that Honorable Papa?
Chair, you have actually quoted Rule 84 and Rule 70, which was repeatedly defied in the House. We've been subjected to screaming matches and insults. And please, Chair, we also have rights as members of this House. It's not only particular members who must be allowed to scream at us, scream at you, and that is taken as normal. It's clear we're dealing with people who are clear to defy the rulings which we have made. And I agree with Member Zulu that entertaining that situation is abuse of the rights of other members in this House.
Thank you very much, Honorable Papa. Paramount to the proceedings here, honorable members, it's the debate and the processes that must unfold. And that's going to happen whether there are members who are prepared to disrupt or not. We will do this until we finish this process. Honorable members from the EFF, may I address you? Honorable members from the EFF, you seem prepared to disrupt this House. I am warning you for the last time. I am warning you for the last time. Honorable Mashamela, sit down. Sit down. Honorable members, please allow the processes to unfold. Allow this member to finish what she wanted to say. I'm not going to entertain other things. Honorable Chair, please continue.
Thank you, Chair.
Honorable Mashamela, I name you.
Ministers and deputy ministers in the House.
Honorable Chair,
Members of the House.
could you please take your seat? Honorable Mashabela. Honorable Mashabela, could you please stop what you are doing? Honorable member, put your hand down. Could you please put your hand down? Could you please put your hand down? Otherwise, members of the EFF, I will have to remove all of you out of the House. All of you. All of you. I'll have to do that. If you continue with this kind of behavior, I will have to do that. Honorable Chair, please continue.
Fellow South Africans, the Supreme Court of Appeal in the case of Freedom Under Law versus Judicial Service Commission had the following to say. I quote, "Public confidence in and respect for the judiciary are essential to an effective judicial system, and ultimately to democracy and founded on the rule of law. Close quote. A fair-minded and dispassionate observer is bound to conclude that Judge Motata cannot properly discharge his functions. The conduct that we have been at pains to describe is of such gravity as to warrant a finding that Judge Motata be removed from office. There is no alternative measure to removal that would be sufficient to restore public confidence in the judiciary. Chairperson, the drafters of the Constitution anticipated that there would possibly be instances in the future where drastic steps such as those spelled out in sections 177 would need to be employed. The JSC has been charged by the Constitution and the JSC Act to inter alia protect the integrity of the judiciary system. This process is about accountability, ensuring judicial hygiene, and building public confidence in the judiciary. As elected public representatives of the National Assembly, our role is spelled out in Section 1771B of the Constitution. The judiciary cannot function properly without the support and trust of the public. Without trust, the judiciary cannot function. And if the judiciary cannot function, the rule of law will not exist or must die. Judiciary discipline is designed to serve core democratic values like judiciary accountability, fidelity to the rule of law, and adherence to public norms of professional conduct. Chairperson, our Constitution is founded on, among others, the rule of law, supreme of the Constitution, and a multiple-party system of democratic government to ensure accountability and openness. Appropriate checks and balances are an important ingredient to democracy. Checks and balances allow for the involvement or intrusion of one arm of government into another to ensure that there is no and over-concentration of power. Thus, the composition of the JSC envisages cooperation in the appointment of judges between all three arms of government, including other stakeholders such as the legal profession and academia. In 2012, the Judicial Service Commission Act Number 9 of 1994 was amended to provide for a written code of judicial conduct, which will not only define what misconduct looks like, but also provide useful guidance to judges on how they should behave. Related to the code is the norms and standards for performance of judicial functions, which are brought into force in 2014. Judge Motata had alleged that as Parliament had not approved a code of judicial conduct, there was no basis upon which he could be charged with misconduct, and therefore demand that the JSC should stop the process in connection with the complaints of misconduct and allow him to resume his duties immediately. Those arguments did not find favor with the court, and his application was accordingly dismissed. It goes without saying that the office of a judge is a respectable one. So must be those who hold it. A judge's conduct in and out of court should not dishonor that high office. Impeccable moral and ethical standard is a crucial hallmark of such a public office. Judges should make every effort to ensure that their conduct is above reproach in the view of reasonable, fair-minded, and informed persons. Judges must exhibit and expose the values of the Constitution. Former Chief Justice Sandile Ngcobo described public confidence in the judiciary as vital to the preservation of the rule of law and ultimately to the preservation of our constitutional democracy. Ngcobo CJ endorsed the famous observation that the judiciary has neither sought nor pays, but only the confidence of the public, meaning that the public recognizes the legitimacy of judicial decisions, even if it disagrees with their content. Absent such public confidence, people may abandon the courts and resort to self-help. The more the public respects and heeds the importance of court decisions, recognizing that their content broadly reflect the moral convictions of the community, the more legitimate the courts becomes as an institution. The ANC supports the report.
Thank you very much, Honorable Member. The Honorable Jafta.
Thank you, Honorable Chairperson. Judge Motata's impeachment is regrettable. His conduct is bereft of conduct expected of presiding officers. Not only did he give wrongful instructions to his lawyers during trial, he also carried himself dishonorable at the scene where the incident took place. Judge Motata no doubt lacks integrity and respect for others. Judicial officers are the flag bearers of judicial integrity. Judge Motata is no such flag bearer. On the one hand, he thrives on racial slurs while preaching constitutionalism on the other. Honorable Chair, this Parliament is often criticized for sleeping on the job when it passes legislation not sanctioned by the Constitution. This is done for the right reasons, and we welcome it. Equally, this means we must rein in judicious judicial conduct. We must not hesitate to uproot conduct that is in violation of the Constitution. Judge Motata has no regard for our Constitution, just as Judge Hlophe. They continue to run down the very Constitution they sought to promote. The only difference between Judge Hlophe and Motata is the extent of their contempt to the Constitution. Judge Hlophe is a serial constitutional offender, and Judge Motata is fast undoing the promises set out in the preamble to the Constitution. We will therefore support this impeachment. Thank you very much.
Thank you very much, Honorable Member. A member from Cope. And PAC is absent. Honorable Heron. Honorable Huaran from the DA.
Thank you, House Chair. Our courts have held that in our constitutional order, the judiciary is an independent pillar of state, constitutionally mandated to exercise the judicial authority of the state fearlessly and impartially. House Chair, as others have indicated, this equal footing with the executive and the legislative pillars of the state, in terms of political, financial, or military power, the judiciary, however, cannot hope to compete. It is in these terms by far the weakest of the three pillars, yet its manifest independence and authority are essential. Having no constituency, no person, no sword, the judiciary must rely on moral authority. Without such authority, it cannot perform its vital function as the interpreter of the Constitution and the final arbiter of disputes between the organs of the state, and ultimately as the watchdog of the Constitution and its Bill of Rights. Now, as Chair, the courts have also held that this manner of conducting business of courts is intended to enhance public confidence. In the final analysis, it is the people who have to believe in the integrity of judges. Without this trust, the judiciary cannot function properly, and where the judiciary cannot function properly, the rule of law must unfortunately die. Now, this is the essence of the judgment in State versus Mamabolo by the then judge of the Constitutional Court, Judge Kriegler, who ironically dealt with an issue or a case that centered on the concept of scandalizing the court. Now, House Chair's judicial independence and the power of the judiciary to strike down any exercise of public power that's inconsistent with our Constitution is one of the defining characteristics of our constitutional architecture. There is no room in this country, and therefore also no room in this debate today, to bemoan and question the power of the judiciary. Let me remind those who would like to revisit the idea of constitutional supremacy, whether in subtle and less subtle public attacks on the judiciary, or by supporting proceedings of dubious structures like cadre deployment committees, that we come from a past in which there was one-party dominance and during which parliamentary supremacy in this country was used and abused to facilitate and enable apartheid and all practices that came with it. The adoption of our Constitution and the supremacy it enjoys in our democratic order was and should remain a never-again moment, which should not be revisited by any argument or action that even in the slightest manner could undermine the judiciary and its independence. However, Chair, the obligation to jealously guard over its independence is also an obligation of the judiciary and the structures that support it, like the Judicial Service Commission. Judicial independence, even while it enjoys, as it should, constitutional guarantees, is not without responsibilities. Judicial accountability is one of these responsibilities that goes hand in hand with independence. Individual accountability is about the openness of court proceedings and the willingness of judges to subject their decisions to scrutiny on appeal. Collective accountability is about taking responsibility as an institution for the proper functioning of our courts and the integrity of the judiciary as a whole. Efficiency in dealing with disciplinary complaints is an important aspect of this collective accountability. Public confidence will invariably be undermined if disciplinary proceedings against judges unfold in the snail's pace manner that typified the Judge Motata matter. Public confidence will be eroded in the judiciary at every instance where a perception could be created that the rights of individual ordinary members of society who suffer at the hands of private actions of judges are not protected in the face of the status and stature of the judge. Public confidence will dwindle every time it's necessary to force the JSC to perform its duties and functions in respect of complaints against a judge in a reasonable and rational manner through legal action. Therefore, Chair, anyone who's committed to the rule of law and our Constitution must be thankful to Mr. Richard Baird, who refused to be intimidated when it seemed the whole world conspired against him, and Freedom Under Law stepped in when the JSC failed to properly exercise its constitutional duties in this matter. Hy is voorsitter, terwyl ons hierdie verantwoordelikheid nakom vandag om die grondwet te beskerm, is dit so dat ons terselfdertyd vir die regterlike dienskommissie moet vra om in die toekoms met groter ywer en spoed te handel met klagtes oor wangedrag teen regters. Die vereiste dat lede van die regbank geskik en gepas moet wees vir hierdie belangrike amp mag nie afgewater of geminag word nie. Daarom is die enigste keuse vir diegene wat die regbank wil beskerm as 'n instelling wat 'n kernrol in ons grondwetlike demokrasie speel, om geen ruimte te laat vir regters wat hulle self aan oneerlike en onetiese gedrag skuldig maak nie. Sulke regters hoort nie op die bank nie. Ek dank u.
Thank you, Honorable Brother. Honorable Janji, you're welcome.
Thank you, House Chair, Honorable Speaker, the Chief Whip, and honorable members of the House. Mandiqale kwamanye amazwe. In a lecture in 1998, the Chief Justice of Western Australia, David Kingsley Malcolm, addressed the issue of independence of the judiciary. And inter alia, he said, I open quote, "In reality, a strong independent judiciary forms the foundation of a representative democracy and observance of the rule of law and human rights. It is primarily the confidence of the community in the legal system which encourages observance of the law. The practice of judicial independence also relies on a community perception that in resolving disputes between parties, the judiciary reflect and act upon the basic and enduring values to which community subscribe." Close quote. The judiciary exercises public power as expressed here, and it is right that there be an appropriate check on such a power. The removal from office of a judge under Section 177, as mentioned here aptly, under the 3 grounds of incapacity, gross incompetence, and gross misconduct on the part of the judge. In this case, it is gross misconduct on the part of Judge N J Motata. The bungalow principles of judicial conduct are designed to provide guidance to judges and to offer the judiciary a framework for regulating judicial conduct. 6 core values are recognized, namely independence, impartiality, integrity, propriety, equality, and finally, competence and diligence. Value number 3, integrity, is essential to the proper discharge of the judicial office. In terms of this value, a judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer. And the behavior and the conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, but must also be seen to be done. In simple terms, integrity means doing what is right, even when no one is watching you. While the promulgation of the South African Code of Judicial Conduct was in 2012, post the incident, it's still worth mentioning as it essentially codified ethical and legal norms which have been in existence prior to 2012. While the actual incident took place in private, South African judges had been guided by ethical considerations in and outside of the performance of the judicial duties. The Judicial Service Commission is the only body empowered with making a finding of either incapacity, gross incompetence, or gross misconduct. The test for whether conduct constitutes a gross misconduct is an objective one. It's not a thumbs up. The Judicial Conduct Tribunal came to the conclusion, therefore, that Judge Motata's conduct at the scene of his motor accident and the remarks he made were racist and that they impinge on and are prejudicial to the impartiality and dignity of the courts. It further found that the lack of integrity in the manner in which Judge Motata allowed his defense to be conducted in his trial as incompatible with or unbecoming of the holding of judicial office. The tribunal posed the question, if Judge Motata is to retain the office of a judicial officer, would this negatively affect the public confidence in the judicial system? That's a question they posed. It is common cause, therefore, that the tribunal answered the question in the affirmative and recommended the invocation of the provisions of Section 177, subsection 1 and A. To fulfill its constitutional role, the judiciary needs public acceptance of its moral authority and integrity and the real source of its power. The Constitution commands all state organs, including Parliament, to protect the independence, impartiality, dignity, and accessibility of this judiciary. It is important that judges at all times seek to maintain, protect, and enhance the status of the judiciary. To that end, they should be sensitive to the ethical rules which govern their activities and behavior both and off the bench. It was found that Judge Motata's racist conduct and dishonesty in the conduct of criminal trial was inconsistent with the ethics of judicial office, thereby rendering him guilty of gross misconduct. Judicial misconduct breaks down the very fiber of what is necessary for a functional judiciary. And therefore, the judiciary cannot exist without the trust and confidence of the people. Judges must therefore be accountable to legal and ethical standards. In holding them accountable for their behavior, judicial conduct review must be performed without invading the independence of the judicial making decision. The Supreme Court of Appeal made the following remarks. The public will therefore demand virtually irreproachable conduct from anyone performing a judicial function. It will at least demand that they give the appearance of the kind of conduct. They must be and must give the appearance of being an example of impartiality, independence, and integrity. What is demanded of them, judges, in other words, is something far above what is demanded of their fellow citizens. And if you want to understand this properly, you only need to look at how in our Constitution we have packaged the three areas of removals. When it comes to holders of Chapter 9, we're saying we remove them if they're misconduct, they are incompetent. When it comes to the president in Section 89, we say we remove them if there's a serious violation of the Constitution and the law, and they are incompetent. But when it comes to the judges, it raises the bar and says gross misconduct and gross incompetence, which fulfills this sentence that it's demanded of them something far above any other ordinary citizens. At this juncture, the National Assembly is called upon to take a decision. And the decision we're taking, Honorable Horn, is a political decision. Because I remember you had a problem with this because you thought political decision is a partisan decision. It's a political decision that was elected representatives. The Judicial Service Commission has made a finding of gross misconduct. Our case law serves a guide on the question of rationality of actions using public power. Decisions must be rationally related to the purpose of which the power was given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. With what the JSC and the Supreme Court of Appeal have said, we as members need to ask ourselves the question, what would justify a deviation from their findings? Somebody says, Ubuntu. Our very constitution is espoused in Ubuntu. We've got the Bill of Rights. So you can't want to work outside of that. Secondly, somebody says, we must get something in between. Halfway house kind of. Something that is not gross misconduct. And the JSC was found wanting when it tried to do that. They then, instead of focusing on gross misconduct, they created a misconduct charge, which is not in the Constitution. And they made a judge to pay R1 million. And I hope that that money is returned to them because the Supreme Court of Appeal rebuked them, that it was wrong what they did. So there's no halfway house that you can build. It's either gross misconduct or you don't meet that threshold. And so that speaks to what Honorable of Al-Jama was talking about, 10,000. It's not done. That speaks to what Honorable Mkwebane would have said, that let's draw sympathy. We are here today for a very particular constitutional duty as this House. While Judge Motata has since retired from active service, we will remember that in our legal system, even retired judges retain their title and may be called to perform public functions as and when required. This process is about accountability. The people of South Africa expect leadership. The Sixth Parliament is on duty. This sitting is not about individual judges. I want to draw your attention to that. It is not about the Justice Committee presenting this report. The significance of this sitting is about what you see on the wall, oversight and accountability, our constitutional duty. If you walk on the NCOP steps, you see all of those pillars put there. Today we're here because of this. We have created, as a sixth parliament, serious footprints of our constitutional duties. We're on duty on this august house. Today is not a day where we must travel the binaries of joy and tearfulness. Because if you listen here, some are joyful, others are tearful. The ANC cannot afford to be in those extremes. Ours is to navigate the difficult issue and take emotions out of what we do so that we are not provoked by those who are joyful. And we don't draw sympathy from fake tears. We must not do that. We are here for a job. We are on duty as this house. We have demonstrated that at this house, the chief whip would have said in Sona that in the history of this parliament, the sixth parliament has passed on the most bills. That's a demonstration that we are not off duty. In the fifth parliament, in a little bit of way, we were off duty when the Inkandla matter was brought to us. So that's off duty. When they brought the matter of section 194, we were on duty. You know what we did. We removed an incompetent and somebody who committed misconduct. We were on duty. When we set up the Section 89 panel to look into the seriousness of the violation of the Constitution in terms of the president, when that report came here, we debated that debate with facts and evidence, and we kicked it out of the window. We are on duty as this house. Asilelanga sitekwa. Because sometimes you are on duty and you lele emsebenzini. It is in the existence of our work that we are recommending the removal of Judge Motata. We have taken time and carefully assessed all relevant evidence at our disposal, applied our minds through a transparent, credible process. In the end, we came to the conclusion that Judge Nkola Motata be removed from office. And if you think about it, we're talking about 30 years of democracy. Today, we're coming here to say to you, in that 30 years of democracy, we have a case that is 15 years old, half our freedom. It is not a standard that we want to create. That can never be a standard. And therefore, the seventh parliament has got work to do so that we're able to speed up all of these issues. And as the Justice Committee, we're doing exactly that. I end off with the following quote from Chief Justice Kajareka of India. Wise judges never forget that the best way to sustain the dignity and status of their office is to deserve respect from the public at large by the quality of their judgments, their fearlessness, their fairness, and objectivity of their approach, and by their restraint, dignity, and decorum with which they observe in their judicial conduct. Today is about us planting seeds for the seventh parliament, because the Siabuya, we are going to come and build on what we have done. I thank you, Honorable Chair.
Thank you, Honorable Chanche. That concludes the debate. I now put the question. The question before the House is that the National Assembly resolved to call for the removal of Judge N J Motata in terms of Section 177, subsection 1 of the Constitution from office. Are there any objections? And I put the question. Those in favor of the call for removal of Judge N J Motata from office in terms of Section 177, subsection 1 of the Constitution will say A. And those against the call for the removal of Judge N J Motata from office in terms of Section 177, subsection 1 of the Constitution will say no. I think the ayes have it, and the objections will be noted. Order. Honorable members, in terms of Section 177, subsection 1 of the Constitution, a judge may be removed from the office only if the National Assembly calls for the judge to be removed by a supporting vote of at least 2/3 of the members of the Assembly. Now, a division having been called, members are required to record their vote for the removal. The bells will be rung for Honorable members, there seems to be a misunderstanding. I'm saying although a division has not been demanded, members are requested to record their vote for the removal. The bells will be rung for 10 minutes. No parla. No parla. Honorable members, order. Please take your seats. I assumed that 10 minutes would be quite sufficient. Apparently, we should have made it 15. Honorable members, may I have your attention? Let me bring to your attention that when voting on this question, the members who have been ordered to leave the chamber due to transgression of the rules will not be called during the roll call vote. These members are Honorable Ntlangwini, Honorable Mhlongo, Honorable Mente, Honorable Mkalipi, and Honorable Gerik. I hope I pronounce it correctly. Honorable members, the rules of the National Assembly provide for different procedures for members to cast their votes. These include voting by electronic means or manual voting procedure by way of a whip or by voice. The rules also stipulate that the Speaker must predetermine the voting procedure. For this division, the Speaker has determined that a manual voting system will be used, whereby each member will be called upon and requested to voice his or her vote. In terms of the rules, all members present when the question is put with the doors barred must vote or record an abstention. This rule does not apply to a member or to a minister or deputy minister who is not a member of the House. Political parties provided a list of members who will be called first when it is their party's turn to vote. After that party's list has been called, the remaining members of the party will be called alphabetically. The Secretary will call each member from the membership list, starting with those from the majority party. Members will be called by their surname, followed by their initials. In order to facilitate this process, I appeal to honorable members to indicate their vote only, without preamble or statement, and without delay. Members must simply indicate yes or no or abstain. This will assist the tellers in ensuring your vote is correctly captured. In the event a member's name is called and they are present, but for whatever reason do not indicate their vote, an opportunity will be provided for such members to raise their hands after the last member is called from the list, at which point they will be recognized to cast their vote. Order. The question before the House is that the National Assembly resolve to recall for the removal of Judge N J Motata in terms of Section 177, subsection 1 of the Constitution from office. Those in favor of the call for removal of the Judge N J Motata from the office in terms of Section 177, subsection 1 of the Constitution will vote yes. Those against the call for the removal of the Judge N J Motata from the office will vote no. Those who want to abstain will record their vote as such. Voting will now commence. The doors to the chamber will remain locked until voting is concluded. The Secretary will now proceed to call members.
Majordina, PCP.
Yes.
Mashatile, SP.
Yes.
Mapisa Ngakula, NN.
Vote yes.
Tinodi, SL.
Yes, sir.
Frolic, CT.
Yes.
Buroto, MG.
Yes.
Dagude, DE.
Yes.
Tseke, GK.
Yes.
Khadebe, BA.
Yebo.
Tsele, BN.
Yebo.
Chikunga, LS. Absent? Oh.
Yes.
Chrissy, BD.
Yes.
Didiza, 80.
Yes.
Dlamini Zuma, NC.
Absent.
Absent. Godongwana, E. Absent. Godan, PJ.
Yebo.
Gungubele, M.
Ewe.
Kivit, N.
Yes.
Kodwa, NG.
Yes.
Kubai, MT.
Yes.
Lamula, RO. Absent. Mantashe, SG.
Yes.
Mtunu, ES.
Yes.
Modise, TN. TR. Absent. Mutsicha, MA. Absent. Mutwaledi, PA.
Yes.
Ndabeni, Abrahams, ST.
Yes.
Chabeni, KPS.
Yes.
Nxesi, TWT.
Self-form.
Nzimande, BE.
Absent.
Absent. Pando, GNM. Absent. Patel, E.
Yes.
Pasha, MJ.
Yes.
Ramuhupa, ML. Absent. Zigalala, S.
Yes.
Zulu, LD.
Yes.
Bapela, KO.
Yes.
Waters, A.
Yes.
Benz, Namasha, Z.
Ewe.
Kapa, RN.
Away.
Lomo, SM.
Yes.
Kina, N.
Yes.
Olomisa, SP.
Ewe.
Jeffrey, JH.
Yes.
Kekana, PS.
Extem, yeah.
Mafu, NN.
Diavuma.
Mahlalela, AF.
Yes.
Mahlobo, MD.
Yes.
Majola, FZ.
Yes.
Makwetla, SP.
Yes.
Manamela, KB.
Yes.
Mangu, LN.
Yes.
Mapulane, MP.
Yes.
Mashiko Dlamini, KC. Absent. Masondo, D.
Yes.
Matale, CC.
Yes.
Mhaule, MR.
Yes.
Muloi, BE.
Yes.
Murulong, IK.
Yes.
Utaung, NE.
Yes.
Nkabane, NP.
Yes.
Nzuza, NB.
Yes.
Pilane Majage, MCC.
Yes.
Skwacha, M.
Yes.
Soju, MM.
Yes.
Swartz, B.
Yes.
Tau, MPF.
Yes.
Chabalala, J.
Dear Tender, yes.
Tolashe, NG.
Ewe.
Chwete, P.
Yes.
Abraham, PN.
Ewe, Dad.
Adams, RC.
Yes.
Adwons, NG.
Yebo.
April, HG.
Moya wami ngithi yebo.
Biokes, AJ.
Yes.
Bilankulu JH,
Navumela.
Bilankulu NK,
Yes.
Bongo BT,
Yes.
Butelezi NS,
Yes.
Kappa N,
Yes.
Chabane MS,
Yes.
Direko DR,
Yes.
Dlamini ME,
Yes.
Dlamini NE,
Yes.
Dlamini SM,
Yes.
Dlulane BN,
Ewe.
Dunjwa ML, absent, Janki QR,
Yeah.
Gancho N,
Yes.
Gela A,
Yes.
Gomba MM,
Yes.
Gumbu TT,
Yes.
Kumede SN,
Yes.
Hadebe BM,
Yes.
Hadebe KER,
Yes.
Harvard X,
Yes.
Hermans J,
Ewe tata.
Hlongo AS,
Absent.
absent, Jacobs F,
Yes.
Jacobs KL,
Yes.
Kumalo FE,
Yes.
Kibi MT,
Yes.
Kwonhof GW,
Yes.
Kotampeko ZA,
Yes.
Kubeka NJ,
Yebo.
Lehwase TI,
Yes.
Lesoma RMM,
Yes.
Letsie WT,
Yes.
Lubengo ML,
Ndikotenda.
Luzipo S,
Absent.
absent. Make JJ,
Yes.
Mabe BP,
Yes.
Mabileta MD,
Yes.
Magaxa KE,
Yes.
Magwanishe G,
Yes.
Mahambehlala T,
Yes.
Mahlaule MG,
Yes.
Mahlo NP,
Kiadumela.
Maumaphelo SOR,
Yes.
Makata TZ,
Yes.
Makubela Mashele LS,
Yes.
Makubele Marilele PP,
Napumela.
Malati T, is it absent? Absent. Okay. Malimeta CN,
Yes.
Malinga VT,
Yebo.
Malomane VP,
Yes.
Mamabolo JB,
Yes.
Mananiso JS,
Yes.
Mandela ZMD,
Absent.
absent. Maneli BM,
Yes.
Maneli ST,
Yes.
Manganye J,
Yeah.
Marekwa GP,
Era.
Maseko Jele NH,
Yebo.
Mashiko MR,
Yes.
Mashele
Yes.
TV, Masiko FA,
Yes.
Masondo TS,
Yes.
Maswale GP,
Absent.
absent. Masuku MB,
Yes.
Masuta TM,
Napumela.
Maswanganyi MJ,
Yes.
Matafa OM,
Yes.
Matebula EF,
Absent.
absent. Matuba MM,
Yes.
Mbata SGN,
Yes.
Mbingo Gigaba BP,
Yes.
Mbuyane SH,
Yes.
McDonald LE,
Yes.
Mchunu TVB,
Yes.
Mdabe SW, absent. Mdakane MR,
Yes.
Mgweba T,
Yes.
Mjobo LN,
Yes.
Mkachwa NT,
Yes.
Mkize ZL,
Yes.
Mkwanazi JCN,
Yes.
Mlenzana Z,
Yes.
Memezi HMZ,
Yes.
Mutle TN,
Youth Employment Service, yes.
Moache RM,
Yes.
Modise M,
Yes.
Modise PMP,
Yes.
New vote Druchen WS,
Yes.
Moela DL,
Yes.
Molala LE,
Yes.
Molekwa MA,
Yes.
Monakedi MD,
Yes.
Morwane ML,
Yes.
Maruashehla PR.
Yes.
Sehla, sorry, apologies for the pronunciation. Motapo MRM,
Ke a dumela.
Motsecha MS,
Absent.
Mbaza TS,
Yes.
Pumza GG,
Yes.
Mpushe PT,
Yes.
Msimango XN,
Ngiyavuma.
Mula N,
Yes.
Mvana NQ,
Yes.
Mieni ET,
Yes.
Myolwa DJ, absent.
Absent.
Ndaba CN,
Ngiyavuma.
Gweng GN, Gweng, sorry.
Yes.
My apologies again. Ngomo Z,
Yes.
Nkosi BS,
Yes.
Nonsele M,
Yes.
Notnachel J,
Absent.
absent. Ngola X,
Yes.
Ngola X, yes. Tobongwana N,
Yes.
Nduli MM,
Yep.
Ndwane JC,
Yes.
Papo AHM,
Yes.
Patrin S, absent. Peacock NP,
Yes.
Pehle PA,
Ke a dumela.
Piri CM,
Yes.
Peterson ML,
Yes.
Pile KB,
Yes.
Kaiso XS,
Yes.
Ramadwa MM,
A.
Ramolobeng A,
Yes.
Siabi AM,
Yes.
Simenya MR,
Yes.
Shabalala LF,
Ngiyavuma.
Sibiya DP,
Yes.
Sihlwai NN, absent, Sigweya RT,
Yes.
Skosana GJ,
Yes.
Somyo SS,
Yes.
Stock DM,
Yes.
Klape MME,
Yes.
Klumelang KB,
Yes.
Tobias TV,
Yes.
Tseki MA, Tseki MA, absent. Chwete B,
Yes.
Shobeka Makeke N,
Yes.
Van Skagweit, Wake SR,
Yes.
Volmarans MJ,
Yes.
Kaba NV,
I vote yes.
Kaba VC,
I vote yes.
Kaba Nchaba PP,
Yes.
Kasa FD,
Yes.
Kego ST,
Yes.
Yabo BS,
Of course, yes.
Zibula BT, absent. Zondi MA,
Yes.
Zuma AS,
I vote yes.
Zongu TRM,
Yes.
Zwane MJ,
Absent.
Steenhuisen JH,
I vote yes.
Kwahube S,
Yes.
Lotriet A,
Yes.
Van der Walt D,
Ja.
George DT,
Yes.
Sarupin AN,
Absent.
absent. Alexander WR,
Yes.
De Villiers JN,
Ja.
Breitenbach G,
Yes.
Horn W,
Yes.
Nodata BB,
Ewe.
Masango BS,
Yes.
Krumbok GR, absent. Marais SJF,
Yeah.
Kola D,
Yes.
Maklua JJ.
Yes.
Abrahams, ALA. Abrahams, ALA.
Absent.
Absent. Bagram, M.
Yes.
Basson, LJ. Basson, LJ. Absent. Begman, D.
Yes.
Bodlani, T.
Yes.
Bond, MS.
Yes.
Bryant, DW.
Yes.
Chetty, M.
Yes.
Clark, MO.
Yes.
Cuthbert, MJ.
Yes.
Engelbrecht, J.
Yeah.
Esak, F.
Yes.
Faber, WF.
Yeah.
Golding, BC.
Yes.
Gondwe, MM.
Yes.
Graham, SJ.
Yes.
Halser, T.
Yes.
Hickling, MB.
Yes.
Hansinger, CHH.
Yes.
Ismail, H.
I vote yes.
Joseph, D.
Yeah.
Gau, KL.
Ke a tshehetsa ntate.
Kanyile, TA.
Yes.
Kumalo, NV.
Yes.
King, CV.
Yeah.
Kriya, HCC. Absent. Legoff, TA.
Yes.
Lease, RA.
Yes.
Lorimer, JRB.
Yes.
Mabena, TB.
Yes.
Mabika, MS.
Yes.
McPherson, DW.
Yes.
Majola, TR.
Yes.
Malati, MS.
Yes.
Marais, EJ.
Yeah.
Masipa, NP.
Yes.
Matsone, NWA.
Yes.
Mbabama, TM.
Yes.
Mbele, ZN.
Absent.
Absent.
Order, honorable members, your noise levels are getting higher and higher.
Mileham, KJ.
I vote yes.
Moore, SJ.
I vote yes.
Mpiti, L.
Yes.
Myberg, NG.
Yes.
Ngobo S.
Yes.
Opperman G.
Extemia.
Phillips C.
Absent.
Absent. Powell EL.
Yes.
Rose AC.
Yes.
Schreiber LA.
Absent.
Absent. Seitolo IS.
I vote yes.
Sharif NK.
Yes.
Shalembe ML.
Yes.
Small JF.
Besliste ja.
Space ERJ.
Ja.
Stab DJ. Oh, Staba. Sorry. Staba DJ.
I did say yes.
Oh, sorry. Terre Blanche OS.
Ja.
Van Dijk V.
Ja.
Van Minen BM.
Yes.
Van Zyl AM.
Yes.
Walters TCR.
Yes.
Weber AMM.
Yes.
Whitfield AG.
Yes.
Winkler HS.
Yes.
Mautwe OMC.
there's a point of order. Honourable Member, what is your point of order?
Chairperson, they recorded Spies as present. She's not present. It was Stubber who's present. So just if the table can note that, because I think there was a mix-up there.
Thanks for assistance.
Mautwe OMC. Mashabela NR.
No, and also no to the biased chairperson who refused the EFF to listen to me. The biased chairperson who refused the EFF to register its objection and call for division. Why do you refuse the EFF to object? You must go back and study the rules of this house. You are a useless chairperson. Very useless chairperson in this house.
Honorable Mashabela, could you please leave the house?
Why? Are you not useless? Are you not useless?
Leave the house.
But you refuse the EFF when they are raising their hands. You don't even
Honorable
check our hands.
Mashabela,
I'm not leaving the house.
please
This is not your house,
leave the
man.
house.
I'm not leaving. It's not your house. It's not your house.
ICT, could you please help us to switch off mics of this nature? Honorable Mashabela, could you please, Wena Mashabela, could you please leave your house, the house? Sergeant at Arms, could you please help her out? Honorable Mashabela, Sergeant Sebleef, the Hayes lot. Honorable Mashabela, please leave the house. Honorable Mashabela, please leave the house. Or I will have to ask members of the security to take you out. Huh? The protection service to move you out. Thank you very much for your assistance. Members of the protection services will be requested to help the Honorable Mashabela to leave the house. Thank you very much, honorable members. Order. Shall we proceed?
Aris LH. Mteza K.
I'm here, I'm here, I'm here.
There's a point of order, Honorable Secretary.
Chairperson, you are breaking your own rules.
There's a
The
point of
doors
order.
were locked and you allow strange people to come into the house. To come inside the house while we are busy voting, you are violating your own rules. You are violating your own rules. You break the rules, Chairperson. How can you open the door while we're busy voting? Well, strange people come inside the house. You are violating your own rules. You are out of order, Chairperson. You are out of order.
ICT, please help us.
Yeah, they must be
Disconnect that
allowed to
mic.
remove me.
Just silence that mic. It's not assisting us. Honorable Kwahube. ICT, could you please help Honorable Kwahube?
Chair, rising on Rule 1122, which indicates that when the doors have been barred, no member may enter or leave the chamber. The concern here, please calm down. The concern here is that now that the members have been allowed to leave the chamber, this has tainted the integrity of the vote. And that is the concern, because it's right here in the rules. The member should have been named and they should have been asked to leave after the division has been called.
Clearly don't know what.
Honorable Kwahube. Honorable Kwahube, I hear you. But the order of the House at this point in time cannot be compromised. I would not allow it.
Then you
If you
choose to break rules of this House, Chairperson.
ICT, please switch off that mic. Honorable Kwahube, we unfortunately would not allow this kind of a thing. It won't be allowed. Shall we continue? Shall we proceed? Honorable members of the EFF, please. Honorable members, please. Honorable Hadebe.
Thank you, Honorable Chairperson. With due respect, Chairperson, if you observe the rules of the House, there can be no point of orders during the division. We just allow the division to be completed and then it is done. So please, let us observe that rule.
Thank you. Honorable members, it is correct that point of order is sustained. We cannot entertain any other thing except the business at hand. We will not allow it. Rule 116. Points of order during division. Subject to all other rules relating to the taking of points of order while a division is in progress. Members may only raise points of order directly related to the procedure during the division. Please. Please. Shall we continue?
On a point of order, Chairperson. Chairperson,
Who's raising a question?
Chairperson, on a point of order,
Who's raising that? I have ordered ICT to switch off that mic. I did not recognize you, honorable member. I did not recognize you. No. We need to continue with what we are supposed to do. Qhubeka nobhala.
Aris LH. Aris LH.
Hallo, thank you. Dankie voorsitter. Voorsitter, ek weet nie hoekom ons moet stem nie, want rule 116 is verbreek. So waarvoor moet ons sê hierdie stemming is nie meer legitimate nie. The table staff are there. What are they doing there? Why don't they advise you? Why don't they advise? They are the legal people there. There are rules in this house. In this house is rule. They are there. Why are they sitting there? If they cannot advise you,
Honorable Aris.
Chairperson, you're wrong. You're wrong, Chairperson.
Honorable Aris, could you please stop what you are doing? Honorable Aris, this woman is, yeah, I have to. Let's continue, Secretary. Okay, just give me their names. Continue, Secretary. You can continue.
Zake. Absent. Chirwa NN. Chirwa NN. Absent. Shonyana KNF. Shonyana KNF. Absent. Kaula MS. Kaula MS.
Niyabona nina niyasidelela nina. Anikwazi uma sifuna ukubuza imibuzo nidlona isitshela sivotele.
Honorable Kaula, Honorable Aris, Honorable Kaula, and Honorable Aris, could you please leave the house? Could you please leave the house? Honorable Aris and Honorable Kaula, could you please leave the house? Honorable Aris, leave the house. Members of the Protection Service, could you please assist the Honorable Aris out? The Sergeant at Arms will take over. The Sergeant of Arms will take over. Honorable Aris, she is not likely to do it. I thought as much. Honorable Aris, the Protection Service will please assist us to help Honorable Aris out of the house. Members of the Protection Service, please come in and help the Honorable Aris out of the house. Honorable members, let's come down, please. May I request that let us take care that nobody comes in, no member should come in, as other members are ushered out. Honorable Hadebe, what's your point of order? I've noted you. Honorable Hadebe, what's your point of order?
Thank you, Honorable Chairperson. Thank you, Honorable Chairperson. What has happened now was to disrupt the voting process of Parliament. I think that act deserves to be referred to the Powers and Privileges Committee, because you cannot be held at ransom by the people who do not understand the rules of the House. They must be referred. Please, those people who have named them, they must be referred to the Powers and Privileges Committee.
Thank you, noted. Honorable Kwahube.
House Chair, I'm rising on Rule 117. The concern here, House Chair, is that this vote has now been fatally compromised. If it is likely going to succeed in a court of law if it is taken on review. This vote is now compromised, and I'm asking you to please apply Rule 117 in recalling for the vote to happen, so that we can make sure that we cross our T's and dot our I's. Letting people in when the closed doors have been closed is now compromising this vote.
Honorable Kwahube, I think you raised the matter and I ruled on it. You raised that matter before and I ruled on it. I cannot be ruled, do it again. I have ruled on that matter. Honorable Melda, we are raising a point of order.
Thank you, Honourable Chairperson. I would like to address you on this specific point because I think it's very important. There's no doubt that the voting procedure has not been tainted in any way whatsoever. Nothing at all. The fact of the matter is, yes, the doors are closed. Why are the doors closed? To prevent other members to come into the House and vote. That didn't happen. But while the doors are closed, we still have a situation that law and order needs to be maintained in the House. If that is not the case, people can run around during a voting session and cause a mock in the House. You acted absolutely correctly. The vote is not tainted. Let's proceed.
Thank you. Order, honorable members. Shall we continue, please?
Hlonyana KNF, Kaula MS, Komane RN,
Chairperson, we cannot be voted here. We are voted for here. So, Chairperson, your point of orders and your recognition should not have eyes. You should also recognize members of the EFF when they want to raise point of orders. It is not the house of the ANC here. The ANC people did not invite us to this house. Please, you must be fair, Chairperson, when you exercise your duties.
Honorable members, please. You cannot just take the mic and shout.
It is because, Chairperson,
you
when I
cannot
the
go
chance
like that.
to talk. You don't want to follow the rules.
Please take your
You
seat.
always recognize your members of the ANC. This is not an ANC caucus. This is not an ANC caucus. This is parliament. It should be treated as
Honorable
such.
member,
So when
if-
you raise points of orders, you must recognize us, Chair. We did not
Then-
come here on favor. We are not invited to come
If
here.
you
We are voted
continue
for
this
to come
way,
here.
I'm going to remove you from the
Okay, you
house.
may
Take your
that is
seat.
what you are good at. You are good at removing us. You can remove me. It does not matter anymore. You can remove all of us. You are used to remove. We are not here on the invite of the ANC. Never. And we are not going to bow
Yeah.
to the ANC caucus. We're not going to.
Honorable
listen to them.
Command.
No.
Honorable
We are not
Command.
here on your invite. We are elected here.
Honorable Command.
You broke
You are
the
out
laws
of
yourself.
order.
I am in
Honorable
order,
Command.
in order. You are out of order yourself, Chair. You are out of order yourself. How do you say I'm out of order? You are out of order yourself. You broke the rules of this house. Now you want us to act as if you are invited here. We're not invited here. We are voted for here.
Honorable
We are
Command.
the same as those ANC caucus of yours. When they raise hands, you recognize them. When we raise hands, you don't recognize us. Why? Why? Is it because we are stepchildren in this parliament? We are not stepchildren in this parliament. We are voted for in this parliament, Chairperson. Like yourself, you are voted for. You do not come here on a favor. You do not do us a favor to come here. Never. Must not treat us like stepchildren here. We are not stepchildren. Never. You must desist from those that you are doing.
Honorable Command. That kind of behavior is totally unacceptable.
The same way as your conduct is unacceptable, Chair. Your conduct is also unacceptable.
Honorable Commander,
How
please
do you
leave the
expect us
house.
to respect you? I will leave it. This
I
is
will
your
remove
house.
you.
You can
Please
keep it.
leave
It's
the
your
house.
house, Mus. I'm
Please
leaving.
leave the house.
I don't
Thank
care.
you very
This
much.
is your house. You can leave it.
Thank
Keep
you.
it.
Thank you very much. Leave the house. Shall we proceed?
Hlophe MS,
Chairperson, you know, we can't be in this house and we must teach you your job. You must rule according to how you feel and we must just succumb to that. What you have done to all the other members of the EFF is totally
I say
unacceptable.
to switch off the
Yeah.
mic. Honorable member, please leave the house. Leave the house. Honorable member, please leave the house. Sergeant at Arms, please assist her to leave the house. Members from the African National Congress, can I kindly request you not to assist me? Could you please not assist me? Shall we continue? No problem.
Madlingozi BS, absent. Mafanya WTI,
Thank you very much, Chair. We all agree that we are going to vote.
Honorable member,
No, listen.
please. Honorable member,
Listen to
please.
the howlers now.
Please.
I haven't even started to vote.
Please.
I haven't even started to vote.
No, no, don't do that.
What must I do?
Guide has been read to you how to go about the voting. Please don't make a speech, don't make a preamble. Yours is just to say yes or no.
The incompetence level on your part.
No, I'm not going
is
to
the one that
entertain.
causes all this commotion.
Honorable
the
member,
people who have to
please.
advise you is the staff that
I
in front
don't
of
need
you.
your advice.
But you listen to others from other parties to give you guidance to what you should do. That I am not going anywhere.
Switch off the
I am
mic. Switch off that mic. Honorable member, you have been read the guidelines. You know what to do. When you stand up to disrupt the House deliberately, I will definitely request you to leave the House. So just stop what you are doing. Please continue.
Makesini M. Makamba Pocha N.
Chairperson, what you are doing is very incompetent. You are incompetent and this is despicable. You are reducing this house
Switch
to a
off the
circus.
mic. Switch off the mic. You are immediately after having spoken to that other member, you repeat the same thing. So it means it's a deliberate move to do it. So we are doing it deliberately. So anyone who's going to do that again, is going to leave the House, right? It's not going to happen again. We cannot be entertaining chaos here. Yours is just to say yes or no. Wapela. If you cannot say that, you don't want to do preambles, you will leave the House. Please continue, Napa.
Makesini M. Absent. Manyi M.
Honorable Manye, please, your response, sir.
You refused the advice. This is the mess you've created.
Switch off the mic. Switch off the mic. Honorable Manye, please leave the House. Honorable Manye, please leave the House. Sergeant at Arms, please help Honorable Manye leave the House. Sergeant at Arms, please request Honorable Manye to leave the House. Honorable Manye, please leave the House. Protection Service, could you please assist Honorable Manye to leave the House? Lead Secretary.
Marais P.
Chairperson, there's going to be a court case and you're going to lose the
Please
case.
switch off the mic. Mevrouw Maria, please leave us with peace.
Matulelwa B. Matulelwa B. Absent. Matthias NS. Matthias NS. Absent. Matumba A.
You refuse the objection of the EFF. Please note that
Please
you
switch
refused
off the mic.
object.
Honorable Matumba, thank you very much for your cooperation.
Mkondo CN. Mkondo CN. Absent. Mkwebane BJ.
No Sobohla Manyosi, Chairperson. You can't be treating us and violating our rules.
Switch off the mic. And please leave the house, Honorable Kwebane.
Mohale T.
Thank you, Chairperson. Chairperson, I'm just worried that you have not allowed members of the EFF to record their votes. So how are you going to
Honorable Mukhale,
account for
could you please
the votes of the EFF?
switch off the mic, ICT?
You have not allowed the members of the EFF.
ICT, please switch off the mic and allow a member to leave the house. Please leave the house, Honorable Member. I am making a request again. Please, honorable members from the EFF, refrain from doing what you are doing. It is not helping us. It's not helping you either. Let's continue.
Mushala MR.
Thanks so much, Chairperson. We really don't support.
Switch off. Switch off. Honorable Msala, please leave the house. Sergeant at Arms, please assist her to leave the house. Please assist her to leave the house. Protection Services. Protection Services, please assist the honorable member to vacate the house. And don't punch them. Order, honorable members. Shall we continue, Secretary?
Muntwedi MK.
Order, honorable members.
Muntwedi MK. Absent. Mtetwa E. Absent. Noluchungu NJ. Noluchungu NJ. Absent. Paulson MZ. Paulson MZ. Absent. Shikwambana M.
Thank you, Chair. Chair, every time when
Switch
you
off,
presiding...
switch off the mic. Honorable member, please leave the house. Sergeant at Arms, please assist him to leave the house. Thank you very much. You may proceed.
Siwisa AM. Absent. Sonti NP.
I'm waiting them to just keep quiet. I'm waiting them, Chair.
Switch off.
Ukhohlwa.
Honorable Sonti. Leave the house. Sergeant at Arms, please assist her to leave the house. Just help her with the bags. Aibo. Protection Services, could you please assist Honorable Sonti to leave the house? Protection Services, could you please move a little bit faster? Pardon? Honorable members, thank you very much. Let's proceed.
Take China, why?
Could you please lower your voices?
Take China, why? Absent. Tembekwayo SS. Absent. Tito LF. Absent. Yako YN. Absent. Shabisa VF.
Oh, relief. I vote yes.
Singh N.
Yes.
Buthelezi EM.
Thanks.
Ngobo SL.
Yes.
Tebekulu RN.
Yes.
Majozi Z. Absent. Buthelezi SA. Absent. Shengwa MD.
Yes.
Shengwa M.
Yes.
Luthuli BN. Absent. Msimang City.
Yes.
Sitole KP.
Yes.
Van der Merwe LL. Absent. Zondo SS. Groenewald PJ. Absent. Malda CP.
Ja.
Vessels WW.
Yes.
Boshoff WJ.
Voorzitter, ek wil net ja sê.
Briet T.
Ja.
Denner H.
Ja.
Groenewald IM.
Ja.
May P.
Absent.
Absent. Malda FJ.
Ja.
Van Staden PA.
Ja.
Meshwe KRJ.
Absent.
Absent. Swart SN.
Yes.
Tring WM.
Yes.
Siekers ME.
Yes.
Olomisa BH. Absent. Kwangwa NLS.
Yeah, yes.
Zungula V. Absent. Mahau TL. Absent. Delil P. Delil P. Absent. Heron BN. Heron BN. Absent. Sheikh Imam AM. Sheikh Imam AM. Absent. Gallo MP. Gallo MP. Absent. Jafta SM.
Yes.
Lekota MGP. Absent. Luate T. Luate T. Absent. Nyonzo M. Nyonzo M. Absent. Hendrix MGE. Hendrix MGE. Absent.
Is Mr. Mafanya present here? If Mr. Mafanya is present here, he should please cast his vote. Pardon? If Mr. Mafanya is prepared to, you can go ahead.
Chair, you gave me an opportunity to do that.
Mr. Mafanya.
And I responded to that. And now that you see I'm remaining alone here, then you come back to me after having attended to others.
Mr. Mafanya, Mr. Mafanya.
Maybe you have forgotten to throw me out as the others.
Please switch off that mic. I have requested that that kind of exercise should not be done, Mr. Mafanya, but you continue to do it. So I would request you to leave the house as well. Shall we proceed, Secretary? Order, honorable members. Honorable members, as I indicated earlier, members who remained present but could not, when called, indicate their vote may now raise their hands, after which I will recognize them to indicate their vote. The Secretariat will assist in that regard. Thank you very much. Honorable members, members who have been present in the House and were called upon to vote but did not exercise their right will be reflected as abstained. Thank you. The voting is now closed. The result of the division will be pronounced. Order. Honorable members, the result of the division is as follows. The ayes, 296. No, only 1, and 13 abstentions. The question is accordingly agreed to, and the House resolves to call for the removal from the office of Judge N J Motata in terms of section. Order, honorable members. In terms of section 177, subsection 1 of the Constitution. This resolution will be communicated to the President. Order. I request members to stand and wait for the chair and the maids to leave the chamber. That concludes the business for the day.